He was the lead negotiator for the government of Pakistan in negotiations with third countries regarding bilateral investment treaties and treaties with investment provisions. He was also part of the team from the government of Pakistan that successfully negotiated an out-of-court settlement with Barrick Gold to settle the exit award of US $6.25 billion. He represented Pakistan in various investment arbitration cases. He completed his BA in economics from University of Toronto in Canada, his BA LLB from University College London, and his LLM in International Investment Law from University of Amsterdam, the Netherlands. Sir, the floor is all yours.
Thank you, and thank you, IPRI, for inviting me to be a guest lecturer. Thank you for the introduction. I won't say I'm an expert. I am joined the Office of the Attorney General in 2020, and I've been blessed to be part of their unit. We worked on various disputes. It was a great opportunity for me to learn and see how things are from the government side when it comes to international disputes. So we'll start the presentation. So what I want to run through firstly is basically the types of arbitration against states and state-owned entities. So these are not per se types, they're forms of arbitration that take place against states or state-owned entities. So the first one is a treaty-based arbitration under by BITs or multilateral investment agreement. So basically you have bilateral investment treaties between two contracting parties, state to state. For example, Pakistan-Turkey bilateral investment treaty, or Pakistan-UK bilateral investment treaty. And then you have multilateral investment agreements, which might be the OIC investment agreement, which is a collective of countries that have come together to form a treaty of treatment of investments and investors. So that's the first part. The second is commercial arbitration. So this happens under commercial contracts, contracts obviously which have been entered into by state-owned entities or enterprises of the state. Obviously they're arms of the state. There's, for example, WAPDA, NHA, and so on. They enter into commercial contracts. These contracts have specific clauses of arbitration. And so those are dealt with in commercial disputes, which goes through different forums like the LCIA or the ICC and so on. The third part is actually arbitration and sovereign guarantees. So these are guarantees provided by states in commercial contracts, and they have their own arbitration clause. What guarantees do is they sort of guarantee to the investor that all obligations of that specific state-owned entity that they have entered into a contract with, the government shall adhere to those obligations, and if those state-owned entities don't fulfill their obligations, as a sovereign, the state assures the investor that they will ensure that their responsibilities are fulfilled. So these are the three types of different methods of arbitration a state is a party to. We move on to Pakistan's history with international arbitration. I'll touch upon commercial disputes. Obviously, we don't have, I put in data, I didn't want to bore you with so many details. So we have, so this is data from 2017 till date. Pakistan has had, well, state-owned entities have had 22 disputes against them. And this is just a table to show the latest disputes and some of the oldest ones. So currently we are the three of them by the same disputing party. It's called Star Hydro. It's a South Korean state-owned entity. And so if you see in the first row, it's the first one is against CPPA, the Central Power Purchasing Agency. It's a governmental organization. It's to do with a tariff dispute. It's in LCIA, it's in the merits phase, and it's still pending. The second one versus GOP, this is actually a guarantee arbitration. It emanates out of a separate arbitration that took place against NTDC, where NTDC was held liable for damages. NTDC did not, refused to pay and is resisting enforcement of the award, and hence they called on the guarantee which was provided by the state. And then we have two LNG cases, one versus ENI, one versus governor. They're both in the merits phases. They're still pending. And of course, there was the famous IPP cases. I'm sure everyone has read about them, heard about them. There's a lot of talk about IPP cases. So Capco versus Wabda was one of those cases. It was in the ICC. This was decided in favor of the investor. The enforcement went on, negotiations went on. It's still an ongoing thing. And then Liberty versus Wabda again in ICC, but this one was decided in favor of the state, and it was settled with Liberty Power. So these are just small snippet of like commercial disputes that the state owned entities are currently embroiled in or were embroiled in previously. We'll continue with investment arbitration under various investment agreements. So till date, there have been 12 disputes under various investment agreements or bilateral investment treaties. I made a small table for reference. So currently we are facing two investment dispute cases. The first one is Oskartalar versus Champak. This is a Turkish-based company. They invoked the Pakistan-Turkey BIT in ICSID, and right now we're in the phase of the appointment of a tribunal. The second one is Bayandar, Pakistan. This is Bayandar 2. Previously there was Bayandar 1, and Bayandar 2 emanates out of Bayandar 1. And this was again in Pakistan, it's a Turkish investor out of a Pakistan-Turkey BIT. And currently we are in the jurisdiction phase of these proceedings. Then there's a Turkey case. This was a gas sale agreement. This spanned, I think, around 4 years, and now we're waiting a final award. We're hoping the award comes in our favor, but you never know. Then, of course, there's a famous case of Karke versus Pakistan. It was a rental power case. It was highlighted significantly on the media. This started in 2013. It was decided in favor of the investor, but eventually Pakistan settled with the foreign investor. Alavi and Progress, again, 2012, but this time this was decided in favor of Pakistan, and Pakistan sought enforcement of the award. Enforcement proceedings are still ongoing because enforcement takes a lot of time. They have to shortlist jurisdictions to enforce the award, to attach assets of that specific entity. So this is an ongoing thing. Then there's Tethian Copper versus Pakistan, again a very famous case, popularly known as the Record Day case, also highlighted significantly in the media. This spanned 9 years. The award came in 2019, obviously in the favor of the investor, and from 2019 to 2022 the parties negotiated and they settled an out of court for the award. And Bayandar 1, Pakistan, this was decided in favor of Pakistan. This happened in 2003. It was settled, but Bayandar 2 emanates out of some obligations that Pakistan supposedly made in Bayandar 1, so that's still an ongoing dispute. So this was just a snapshot of different disputes that Pakistan is a party to. What I wanted to run through actually, and the main focus of my lecture, is highlighting two key disputes. And these two disputes everyone knows of. The first is the Karke dispute. It's a rental power case. It was highlighted significantly in the press, globally and locally. It has been subject to many different readings, lectures, op-eds. So I want to run through as to what happened in the Karke dispute. So in December 2008, Karke signed a contract with Lakra Power. Lakra Power was a state-owned entity providing rental power. They signed an agreement in 2008. They replaced it with a new agreement in 2009. And the same year in July, Transparency International wrote to the minister and said, I think there have been massive allegations of corruption in the contract, so you should review it. The minister did not heed to what the Transparency International had to say. And then in September 2009, a parliamentarian, Mr. Faisal Saleh Hayat, he wrote to the Chief Justice, the then Chief Justice Iftikhar Chaudhry, and said, there's been a lot of corruption in the award of the contract, and you should take a look into this. And immediately, I think it was 3 days after he wrote the letter to the Chief Justice took a suo motu under 184.3, and so the case was fixed for hearing. Eventually, after 3 years, on March 12, the Supreme Court pronounced its judgment. And what it did was it declared all RPP rental power projects since 2008 void ab initio. So void ab initio means they were void since the beginning, since their inception, and they ordered a NAB investigation into the corruption of one RPB sponsors, which was the foreign investors, and then the government officials who were part of all these RPP negotiations. I didn't have a slide in this, but I want to go through as to what happened to the foreign investor once the Supreme Court judgment came. So once the judgment came, NAB put all of Karki officials, including its owner, Mr. Karandas, on the exit control list, and they froze all of Karki's bank assets. NTDC, which was part of the contract, they instructed Karki to seize all electricity dispatched from the ships, and then Karachi Electric. So the vessels of Karki were parked in Port Qasim. They were providing electricity. Karachi Electric stopped all supply of power to those vessels, and so the crew of the vessels were left without power since 30th March 2012. And then eventually Port Qasim informed Karki that since there's a NAB inquiry going on, your vessels cannot leave Pakistan. So they put their officials on the exit control list, they froze their assets, they stopped power to them and their crew, and they stopped them from leaving Pakistan. One vessel, which was the biggest one, it was called Kaya Bay. It remained idle from 012 to 014 without power, without anything. And the other two vessels, they remained there without power or anything from 012 to 2020. So 8 years, two vessels were parked in Port Qasim without anything to do, and the crew on board. So what Karki did? What did Karki do? So Karki, obviously a foreign investor, had the only option they had was go to investment arbitration. They sent a notice of dispute in 012, and in 013 the request for arbitration was registered in ICSID. The tribunal was constituted in 013. Two hearings took place on provisional measures in September and October. So under the ICSID rules, there's an article which you can invoke to request provisional measures, where an investor can ask the tribunal to mandate a state to seize the measure in place or stop them from doing something provisionally so that their rights are not infringed. So the request for provisional measures was given, and then on October 13, the tribunal ruled that one vessel, Kaya Bay, it should be released to international waters, but kept the other two there, pending obviously the tribal's consideration on merits and jurisdiction. And then in August 2017, the tribunal issued its award. And it's a very interesting award. I want you all to read the award and how it deals with the Supreme Court judgment in itself. It says, firstly, there was insufficient evidence of corruption, especially since there was any lack of corruption findings in the Supreme Court. So the Supreme Court did not find any corruption. They ordered NAB to find corruption and said, you do the investigation and you come up with the corruption and you prove that the corruption has occurred in this contract. They held that Pakistan expropriated Karki's investment through the Supreme Court judgment, essentially saying that this judgment infringed the rights of Karki, and everything that subsequently happened, the seizure of the vessels, bank accounts, NAB investigations, they indirectly expropriated Karki's investment and directly expropriated it. Pakistan also breached its obligations in free transfer of capital by the rest of their vessels, their bank accounts, and so on. So the tribunal awarded Karki $500 million plus interest on different amounts. So there were different heads of amounts. There are about 10. And interest was compounded annually since 2012. So by the time the dispute was settled, the liability stood at $1.2 billion. And I think the dispute was settled sometime in 2019. So what happened? After the award, Pakistan initiated annulment proceedings in 2017 through ICSID to annul the award, and Karki tried to enforce the award in different jurisdictions against Pakistan and different Pakistani assets abroad. In the meanwhile, Pakistan uncovered additional evidences of corruption through different MLAs and different investigations it was carrying on, and they initiated revision proceedings in ICSID. So when revision proceedings, You can apply to exceed, I think it's under Article 54 of the exceed rules, to revise an award because you found new evidence based on new facts that the award that was rendered was based on facts that were not present at that time and have new facts uncovered that will effectively hinder the award's final liability or the state's final liability. But in between, settlement talks took place since 2017, and in 2019 October actually, the governments of Turkey and Pakistan, they got together, their officials got together, and they tried to resolve all outstanding disputes, including the Karke dispute. And it's funny because they met one day, and the next day, Karke and the governments entered into a settlement agreement. So it took 1 day, or maximum 2 days, of governmental intervention for the dispute to be settled. And so, obviously, the terms are confidential, but what you can glean from the media that they entered into a settlement agreement, so all claims against Pakistan were waived by Karke, so Pakistan did not have to pay 1.2 billion or any of the interest on the final award. Pakistan was to return the vessels to Karke, seize all investigations, but limited to Karke officials. Investigations still continued on government officials on our side who were supposedly part of the contract and entered into corruption. So this was a highlight of the Karke dispute.
Can you explain the last point, but not the government officials?
So, in the settlement agreement, obviously the foreign investors said, we are investors, so we don't want to be brought to your courts because there is no solid proof that we did any corruption. NAB was continuing their investigation, but the terms of the settlement were as such that Karke wanted their foreign personnel to not be part of the investigation as part of the settlement. But obviously, since there was a Supreme Court judgment in place which ordered investigations, the government could not waive off that, and so they continued investigations in the government officials part of the contract itself. But when it came to the investors, they were sidelined.
So what's the latest date of the case of the government officials who were under scrutiny charges?
I think it's part of the NAB. It's part of the NAB's proceeding. I can't comment further on it. It's part of. There's obviously NAB.
I think it was president of
It's a con.
who gave up all the he came in and then 1.2 billion worth.
So the government was involved. Negotiations were happening before, but they couldn't come to a common understanding because the award liability was so much. And then obviously because Turkey and Pakistan enjoy bilateral relations, it was
Both the PMs.
they met, and then eventually Karke. So Mr. Karandaz is a very big businessman in Turkey, and so that's how the settlement eventually took place. So this was one of the disputes, one of the biggest disputes, and one of the biggest liabilities Pakistan had to face. The other one is the record dig dispute, very famous case. Everyone knows about it, and I think everyone knows more about the record dig dispute than they do of the Karke dispute, owing to the media coverage it took and how it played out in the Supreme Court and afterwards international arbitration. So I'll give you a run through of what happened. So in '93, the BDA, which is the Balochistan Development Authority, it entered into a joint venture with BHP, was British Petroleum Minerals Explorations, and they entered into a joint venture agreement, which was titled Chajwa at that point. In 06, TCCA, it bought BHP's interest in Chajwa. So TCCA was jointly owned by two companies, Barrick Gold of Canada and Antofagasta of Chile. So they were 50% owners of TCCA, and they bought BHP's interest, and so took over the rights of Chajwa. And then 5 days later, someone filed a constitutional petition in the Balochistan High Court to nullify the Chajwa. It took a year of proceedings, but the Balochistan High Court upheld the agreement, JVA and other agreements that TCC had entered into with the government. And so eventually the petitioners appealed to the Supreme Court in 2006 or in 2007, if I'm not wrong. So the appeals were pending before the Supreme Court. Meanwhile, TCCP, the Pakistani corporate entity, kept working. And on 15 February 2011, they applied for a mining lease to the provincial department, mining department, which was denied by the DG Mines. And on 15 November, actually, I think around 10 months after the application, the DG Mines denied their application for a mining lease, essentially saying you cannot mine in the Record area. So what did TCCA do? TCCA on 28th November initiated 2 arbitration claims. One before ICSID for violations of Pakistan of its obligations under the BIT, along with the request obviously for provisional measures, and the second in ICC. Now ICC, the International Chamber of Commerce case, was against the government of Balochistan specifically, because it was the one entity, the BDA was the entity of the GOB, and so they were the ones who entered into a contract. So this was a contractual dispute. The claims arising out of the contract went to the ICC. Claims arising out of a treaty for obligations that Pakistan breached in the BIT went to ICSID in investor state dispute settlements. After that, in 2012, various constitutional petitions were filed. I think around 7-8 were filed together, and so they were clubbed together, and there were hearing commenced in Supreme Court in 2012. Round of submissions took place, and towards the end of the year, in December 2012, the tribunal that was constituted in ICSID, they ruled on provisional measures, and they said Pakistan would not give Recordic over to any third party until the dispute is resolved in arbitration. So not till the dispute is resolved in Pakistan, until the dispute is resolved in international arbitration. And then in January 2013, the Supreme Court gave its verdict. It held that the Chedwa was illegal, void ab initio, again, the same thing, void in its inception. And as a consequence, all agreements that flowed were also void, and then they ordered NAB to investigate allegations of corruption. And so, same story repeats itself after Karke. We go to ICSID and ICC, and in 2014, the ICC tribunal issued its own ruling related to the contract, and it dismissed Balochistan jurisdictional objections, and it concluded that as a matter of international law, it was not bound by Pakistan's Supreme Court judgment, and it could proceed to hear TCC's merits on claim. And it's a very interesting ruling. I advise you all to read it as to how they bifurcate a state's obligations internationally and a state's obligations domestically. In September 2015, the GOP filed an application before ICSID to have TCCA's claim dismissed on allegations of corruption. Obviously, there was an NAB investigation going on. Pakistan reduced evidence, and in November 2017, the tribunal ruled on Pakistan's application. So there were 2 rulings in 2017. One was on jurisdiction and liability, where the tribunal held it had jurisdiction and it held liable the government of Pakistan that it had infringed on its obligations under the BIT. And the second ruling was on Pakistan's application for corruption, and it dismissed Pakistan's application. And so that ruling also, it's a 400-page ruling. It's also a very interesting read as to how they tackled the issue of corruption, the evidences, how Pakistan reduced evidence, witness statements. So that's also one of the very good reads you should go through to see how the tribunal handled the issue of corruption and the interplay of international law and domestic law.
Excuse me. One thing I would like to clarify. In the last slide, when Pakistan went to ICSID and the case went to ICSID for the first time, in 2013, I think, you should.
It was, so in 2011 they initiated the claim. In 2012 it was registered in ICSID. So that's when this claim.
Initial decision, I remember it was for the Pakistan.
That was the provisional measures. So when I said,
Okay, you mentioned me.
so
I know something that I feel
I think I wrote it. I don't know if I. Let me go back and see. Achani, I think that I thought I wrote it, but I'll tell you what it was. The request for provisional measures. Basically, the request for provisional measures was that TCC asked that all work be stopped in the Reko dispute. And so what the tribunal ruled was, so the claim was the dispute was around 3 pits. So pits being the mining pits. It's H14, H15 and H13. And then there was H4, which was Tanjil, which was a copper deposit. So what TCCA wanted was Pakistan to halt work or not give it to anyone completely. So H4, H13, H14, H15 would not be given to anyone. What the tribunal did was they said no. So H4 Pakistan can work on, which is the copper deposit in Tanjil. H14, 13 and 15, which is part of the big Reko area and the EL5, that will not be given over to any third party. And that will remain the subject of litigation and arbitration. But H4, Pakistan was free to do whatever it wants, but it had to inform the tribunal at every step what it was doing in H4, what the demarcations were, what work they were doing, and if they infringed on EL5, where the other deposit was, they would have stopped, the tribunal would have effectively stopped Pakistan from doing it. So good point. I think I missed that slide.
And they were 23 protesters. Out of 20.
But three were mined. Three were mined. 22 were explorations, but 3 were actually properly explored. And so eventually in July 2019, the tribunal issued its final award, and it ordered the government of Pakistan to pay 4 billion in damages, 1.7 billion in pre-award interest, and 61.98 million in cost of litigation. And this is an interesting figure. The cost of litigation run into the millions because the case went on for 7 years. There were submissions that spanned thousands and thousands of pages, thousands and thousands of hours of work. And so this cost is a true reflection of the cost that the state has to bear when it goes to international arbitration. The tribunal also ordered post-award interest, which was approximately around $740,000 a day on the award itself. And so the liability before it got settled finally was at $6.5 billion for Pakistan. And so what happened after? Obviously, TCCA, having a $6.5 billion award in their hand, they initiated enforcement proceedings against the state. So they went to the United States, they went to Australia, and they went to the British Virgin Islands in 2020. And I'll get to that as to what happened in the British Virgin Islands. Pakistan obviously wanted to pursue all legal avenues, so it applied for annulment proceedings in 2019 and revision proceedings in 2021. On the 16th December 2020, so what happened was, and I think it's been part of a lot of media coverage, so the BVI High Court issued an order where it appointed a receiver on PIA's assets, which included the Roosevelt Hotel and the Scribe Hotel, to enforce the award. Now this was an ex-party order. Pakistan was not present at the hearing. TCC applied for enforcement, they recognized their award, and the High Court issued an order, and then sent notices to Pakistan, PIA, and its subsidiaries in BVI. So effectively what happened was they preliminarily attached PIA's assets. They couldn't be moved. PIA was shackled in a way. They couldn't do anything about their hotel. They couldn't do anything about their own assets in BVI. And so a round of litigation took place after several rounds of submissions. In May 2021, the BVI court dismissed TCC's application and all PIA's assets were released. So Pakistan was successful in waiving off that enforcement, but TCC filed an appeal against the order, which was pending till, of course, the award was settled. And then they also applied for enforcement in the US, in the federal court in New York, and the Australian High Court. Both gave preliminary orders that they recognized the award and they would continue enforcement against Pakistan's assets in those jurisdictions. And so what was the option left for Pakistan at this point? They had a $6.5 billion award, they were facing enforcement, PIA's assets were getting attached. And so what the government of Pakistan decided, they would form a committee to negotiate an out-of-court settlement with TCC. given the size of the award, they thought it best that they should negotiate with TCCA. So negotiations commenced in 2020, and it took 2 years, but they eventually came to a settlement on 15 December 2022, which was post Supreme Court reference. I'm sure you're all aware that a reference was moved to the Supreme Court, which sort of gave its cover on the whole negotiating process and the agreements. And broadly speaking, the agreement was that so Barrick Gold, one of the entities of TCCA, would return to the Reko Diq project, and Antofagasta, the other half of TCCA, took a financial settlement of their share of the ICSID award.
And this was paid by Barrick Gold or government of Pakistan?
No, so Antofagasta's liability was paid by government of Pakistan, the settled amount.
Any idea how much was this? Just for knowledge.
So basically the award was 6.5 billion for TCCA, and so Barrick, so they had 50-50% partnership. So Barrick was over 3.25 billion, Antofagasta was over 3.25 billion. Barrick waived their 3.2 billion to come back and work on the project as 50-50 partners with the government, and Antofagasta waived their 3.2 billion for a financial settlement of 900 million. So essentially, 900 million. So essentially, a liability of 6.5, which does not include a potential liability in the ICC case. So this was just an ICSID case. The ICC case under contract, and we obviously took some opinions from lawyers working on that case and in the UK, would have been another $2 and $3 billion. So total liability for the state would have been around $9 or $10 billion. So that was settled for 900 million eventually, with one party coming back to work on the project. So this was a broad snapshot of what happened in the Reko Diq dispute. So keeping those two in mind, the two disputes I just mentioned in mind, why is it that investors go for investment arbitration? And this is in the context of Pakistan specifically. So why would an investor go to investment arbitration? The first one is it depoliticizes investment disputes. Now, what does a depoliticized investment dispute mean? It means that when a dispute has come, it is not made subject of political and media hype. That's in the Pakistani context. As you've seen in the two cases, they became heavily politicized. It became a battle, firstly, in the Kake project, it became a battle of corruption. It became a battle between different political parties as to who's corrupt, who did this and who did that, pointing out specific individuals. And in the end, it was the investor that got the brunt of the whole deal. And then Reko Diq, again, a politicized dispute between GOP, and then obviously the Supreme Court. Then there were allegations of corruption against government officials. Again, it was subject to a lot of media hype, a lot of controversy, and so, as you all know, the dispute the Supreme Court held it was void. So that's one reason why investors would want in Pakistan to go to arbitration, so that they can avoid this politicization of disputes essentially. The second one is adjudicative neutrality. Obviously, investors generally do not want to go to domestic courts, be it any jurisdiction, but they're especially scared of going in jurisdictional courts of Pakistan. The reason being, as we all know, cases take years to conclude. It starts from the very low levels and goes up to the Supreme Court, and it takes years. The investor, firstly, does not want to spend, I would say, around 7 or 8 years in adjudication where the investment is stopped without any hope that they might be able to recover it eventually after those 7 years. And then they don't have a trust in the judicial system. Foreign investors generally are very wary of domestic courts. They view them as politicized, as influenced, and so investment arbitration gives them neutrality and control over the proceedings in a way. The third is it's investor friendly. We've seen different cases in ICSID, ICC, LCIA. If you look at a snapshot of different cases and how they've been settled. Most of them have been in the favor of the investor, and most of them against the state. That being said, Pakistan has had substantially good record, except for Karki and Rekodik, when it comes to investor-state disputes. But still, investors would always prefer going to investment arbitration instead of local courts. And so it also allows investors control of the arbitral procedure. In domestic courts, you have a judge, you have a single bench, you have a double bench, you have a 3-member bench, and that's up to the that's in the control of the judiciary at that point. In arbitration, you get to set the rules of the arbitral procedure. You get to set the rules of, if you have one arbitrator, you have 3 arbitrators, and you pick an arbitrator that you want. So you have a degree of control as to how the arbitral proceeding will take place, under what rules it will take place, what the rules of the specific arbitration be, including evidence. So it gives a greater degree of control to the investor as to how the whole dispute will flow. And then obviously it's enforceability of the awards and compensation, which ties in with the last point as well, which is the penalty to the investor. So once an award comes, the investor has the option of enforcing that specific award in any jurisdiction in the world where the state has its assets, as was the case in Rekodik, as was the case in Karke. And the modicum of compensation awarded is usually quite high. Tribunals use, it's an often controversial method. It was a DCF method. It was used in Rekodik as well, where they would claim a certain amount, XYZ, and then they would settle at a significantly larger amount, though lower than what they claimed, but still significant in that sense, using that DCF method. So that's one of the advantages the investors have when it comes to going to investment arbitration. But this is specifically in the context of Pakistan, and generally as well over the world, all over the world, investors prefer going to investment arbitration. So lastly, what can Pakistan, or what can governments and state officials do to minimize the risks of investment arbitration? So the first one is information sharing between government departments, and this relates to prevention of measures to prevent and decisions or actions by a state, and it's particularly at sub-national level. So we have obviously, we have federal government, we have provincial governments, and post 18th Amendment, much has been devolved to the provincial governments. So provincial governments enter into contracts, and so Rekodik was one of those. It was a Chajwa, and then they violated that contract. And so what needs to be done is there has to be a medium of information sharing between all these departments, provincial and federal, when it comes to commitments undertaken by the state at the international level. They have to identify specific sectors which are prone to this. An important issue here is actually it's the continuity of information flow. So we have a board of investment. It deals after foreign investment and foreign investors, and so they have provincial BOIs as well. But information sharing is not continuing. People come and go from BOI. Things get lost. It's bureaucratic. There's all red tape. No one maintains things. And so one doesn't really know what contracts governments have entered into. Then there's no repository where you could go and check which contracts the state has entered into, what the obligations are. So information sharing is a very important part of trying to minimize disputes in the future. The second one is it's targeting sensitive sectors. What it means is, so the bulk of investment disputes just focus around sectors which are more economic activity. And in the case of Pakistan, it's mostly mining, petroleum, or power projects. And so a lot of state contracts, concession agreements for public services are made in these 3 sectors mainly. So what happens is, and what ideally should happen, is that once you identify what your sectors are, where foreign investment is taking place, you list them. And so in order to avoid violating any commitments under those contracts, there should be again information sharing, and there will be good practices upon how to enter into contracts. What contract, if you enter into a contract, what the specifics of that contract is, what are you entering into, what obligations you're accepting, and what obligations the state will have to incur, which ties into my third actually point, which is trainings on contract negotiations. So more often than not, states or state entities enter into contracts hastily, mostly because of it being politicized in a way. They enter into contracts without going through the various nitty-gritties of how it could affect governments and states, and they take on onerous obligations in those contracts. And so that's happened in the case of Karke as well, where it was a policy decision to have rental power projects, and so a multitude of rental power projects came, the contracts weren't properly looked into, and so the state landed into trouble. And so there has to be trainings on how to enter into contractual agreements, what the obligations are, what obligations one can put on the investor in those contracts, and obviously what the dispute settlement clause is. The forum you select, the seat of arbitration, the governing law play a vital role as to how the dispute will end up and how the dispute will play out if it goes to a dispute. So that's very important. The other one is in administrative review procedure and mechanism. So administrative review essentially is a review mechanism that you afford to an investor before they go to investment arbitration. And so in Pakistan, what we've done post Recordic, when Recordic was settled, it went to the Supreme Court. The government introduced a Foreign Investment Act. It's I don't know the exact terminology, but it's an Investment Act of 2022. And so they created an investment ombudsman. And so what the idea of the investment ombudsman is that it's empowered in a way that it will take on cases that investors have. So if an investor is aggrieved by an administrative measure or something that the state government did or the federal government did or any of its departments did, it can approach the investment ombudsman and say, look, this is the measure that took place. So let's say some tax was rescinded, some tax concession was rescinded by the government. They go to the ombudsman, they say this has happened, this measure has infringed our investment, and if this keeps going on, we have no other option but to go to arbitration. So the ombudsman looks at the case, looks at the facts, and the ombudsman can direct that state agency or that state department to rectify that measure before it escalates into arbitration. We've incorporated investment ombudsman in the model BIT as well. We're currently negotiating BITs with different countries. They're very open to the idea of investment ombudsman. Obviously, it comes with a lot of different things, its rules, procedures, how it will act. But this stopgap mechanism is essential because neither the investor nor the state wants to go to investment arbitration. It's lengthy, it's costly, it takes time. In the end, the state has abundant resource to go through arbitration, but again, that's resource of the public, it's public money, and so it's wasting it on arbitration is not the ideal course of action. So the investment ombudsman is sort of a thing in the middle which would rectify or sort of allow investors go between before going to arbitration. And again, there's the last one, it's capacity building of government departments and the judiciary. Government departments, especially because they're the ones who enter into contracts, they should know what treaties Pakistan has entered into, the obligations that have to be taken on, and what obligations they will be taking on when they enter into contracts which has an arbitration clause. They have to be sensitized as to look after those contracts, adhere to their obligations, and they should know or they should be trained as to what, if they violate the contract, what it would entail in the future for the state and the state government or the federal government. And then the judiciary. There have been many trainings, I believe, on international law of judiciary. But if you see, if you read the Supreme Court judgment in Recordic, you'll notice how sometimes it gets lost in translation, how domestic law and international law plays out. What happened in Recordic was, I think in the judgment, the Supreme Court said, they told the tribunal to stop their proceedings. And then the tribunal in return said, we respect your view, but that's not how it works. You have your international law commitments. You cannot rely on your domestic legislation and domestic framework to renege on your international law framework. So a lot of still training has to go on when it comes to investment arbitration, international law. And then lastly, state-to-state dispute prevention. This happened in Karke, where things escalate to a point where states, governments level functionaries have to intervene bilaterally through the Foreign Office or through different ministries to come to a settlement. That happened in Karke as well. But this obviously is the last resort of a prevention. If it comes to that, obviously, the State Department or the contract or the state itself cannot afford to hamper its own bilateral relations with states and their investors who invest in Pakistan. So that should be the last option that the government has to go through when it comes to investment disputes. Thank you. That was the end of my lecture. I hope it was not so boring, and I hope you learned something from it. If you have any questions, I am here. All right, no questions. That's good. Okay.
आवाज आ Thank you so much. In fact, you made many complex issues of Karke and Decodec very easy to understand. Am I correct in my reading that judicial part, I mean, with regard to the awards given by the arbitrators, there was a specific Supreme Court judicial activism was also quite visible, because if you recall, Karke and then Recodec was during Musharraf's time, and then it continued, and Karke, then the steel mills, privatization and all that. There was a background to these cases because they could not, in fact, pin the blame. They could not identify the corrupts involved, but they spoiled the whole broth. One, secondly, it dented Pakistan's credibility internationally, and it served to be a bitter lesson for the investors to come to Pakistan. Thank you.
Thank you. Point well noted. Obviously, we've all been through the whole Karke and Recording dispute when it happened, and it goes back to my point of trainings through judiciary on international law, so that they know what obligation the state has entered into, what will happen if Pakistan infringes on those obligations, and how judicial decisions are essentially noted as obligations of the state. So judicial decision is definitely an indirect expropriation if it comes against the investor, and an investor feels aggrieved by that decision. They take it to international courts and say, you know what, this decision indirectly expropriated our investment. So they play a big part. Judicial activism on one side, obviously, it's the court's prerogative to take on cases. How it plays out, how the court was affected, or I would say unaffected, by media hype or politicization, that's been written about extensively, so I won't go into that. But again, I think the essential point is trainings when it comes to our international law obligation. That's the fundamental part if we want to mitigate a Karke or Recordec in the future for the state.
Shouldn't someone file damages against the Chief Justice of the
I can't comment on that, but if an agreed,
the losing party, has to pay the damage.
and maybe some other concerned citizen like yourself would be open to that. I don't know, but that's a decision the public has to take.
We are hopeless. We were hopeless, but we are hopeless now. We have nothing in this world.
Any other questions? No?
Really? No.
Was it a good lecture then, I guess?
Most of cases showed us in the beginning, BIT cases.
They are related to the power sector, बहुत ज़्यादा हैं. तो why is it so? क्या ये हमारे जो IPPs के laws हैं उनमें कोई issues है, or do we commit the same mistakes every time? Because there were, I think, dozens of cases जो सिर्फ power sector के.
I think power, so Pakistan main sectors जो हैं वो power, energy is one of the biggest sectors जहाँ पे for investment होती है. You know, apart from IPPs we have dams की होती है, solar होता है, coal होता है, so energy पे बहुत focus है investment के ऊपर. So there are a lot of different contracts. You know, there's multiple of contracts होते हैं, tariff के होते हैं और different चीज़ों के होते हैं, ये होना है, tariff ये set होना है, इस तरह की चीज़ें होनी हैं. पॉलिसीज़ जो है पाकिस्तान की दिस चेंज अलॉट. असल में पॉलिसी कंटिन्यूएशन का भी इशू होता है. एक पॉलिसी पावर पॉलिसी आई है, फिर वो एक और गवर्नमेंट आके पावर पॉलिसी चेंज कर देती है. एंड सो इन दैट टाइम जो इन्वेस्टमेंट होती है, जिस इन्वेस्टर की होती है, वो कहते हैं अच्छा हम एक वी इन्वेस्टेड विद अ सर्टेन थिंग इन माइंड, वी मेड अ कॉन्ट्रैक्ट एंड नाउ वो चीज़ उल्टी हो गई है. जो मैंने द वंस आर लिस्टेड ऑब्वियसली देयर डिफरेंट हेड्स. एक टैरिफ के ऊपर है, एक सेवन गारंटी के ऊपर है, एक लिक्विडेटेड डैमेजेस पे है. सो इट कम्स बैक टू द पॉइंट जहाँ पे कॉन्ट्रैक्ट आप नेगोशिएट करते हैं कि व्हाट ऑब्लिगेशन द स्टेट इज टेकिंग ऑन, और वो टाइम फ्रेम क्या है, आप क्या कर रहे हैं क्या नहीं कर रहे. व्हाट इन्वेस्टर्स आइडियली वांट इन कॉन्ट्रैक्ट इज अ स्टेबलाइजेशन क्लॉज. सो स्टेबलाइजेशन क्लॉज होता है कि वो स्टेबलाइज कर देते हैं अपने कंसेशंस, टैक्सेस, एग्रीमेंट, कि जी हम इस एग्रीमेंट के अंदर जो हमें आप कंसेशन दे रहे हैं दे स्टेबलाइज्ड एंड यू वोंट टेक देम बैक. इफ यू टेक देम बैक तो यू आइदर गिव अस अल्टरनेटिव एग्जाम्पशंस दैट आर सेम एज द वंस वी गॉट इनटू, या आप हमें इन्हीं पे कंटिन्यू कर देते हैं. सो इश्यूज ये भी होते हैं हमारी असल में एनर्जी नीड्स ऐसी हैं, चीज़ें ऐसी हैं, पॉलिसीज ऐसी हैं, कभी कभार टैक्सेस इंक्रीज हो जाते हैं, वो हर एक पे करने पड़ते हैं. एंड देन जिस कॉन्ट्रैक्ट जो आपने उससे पहले 10 साल पहले एंटर किए होते हैं, वो इन्वेस्टर कहता है जी मैं तो वो टैक्स नहीं दूंगा अब, एंड देन issues come up. So yeah, it's quite multitude of things hoti hain. And then
Additional question. Yesterday we had a long discussion with different panelists. There's one point which came up about the BITs. Are the BITs, so to say,
Useful for FDI or no? Because there was a view that BITs are important, they increase the FDIs. There was a view BITs जो हैं वो inhibit करती हैं FDI को, और the example was given, I think Bolivia का केस था और some other country, कि जो उन्होंने जब BITs ख़त्म किए तो उनकी FDIs increase होगी. I don't know your views.
अच्छा, firstly there's no concrete evidence कि BITs increase or FDIs or decrease FDI. ऐसा कोई मतलब there's all research, there's all writing.
ये मैं सारे क्वेश्चन आप लोगों के बिहाफ पे कर रहा हूँ, तो ताकि आप सोचने क्वेश्चन. अभी आप लोग एक को भी करना. Sorry.
Interestingly, so the first BIT ever that was signed was between Germany and Pakistan. This was back in the 1950s. So we are technically the pioneers of BITs in that sense. You have to go to the history of BITs actually to know कि BITs का कोई फायदा है कि नहीं है. BITs came into being in the 1960s, 70s, 80s जब capital exporting countries ने कहा कि जी now we want to export and go into capital importing countries. Capital importing countries ने कहा we need investments, बाहर से हमें technology sharing चाहिए, हमें इनका infrastructure चाहिए ताकि हम अपना infrastructure बना सकें. BITs was that mechanism जहाँ पे countries ने कहा कि जी हम अपने investors के rights कैसे protect कर सकते हैं, which is through a BIT, कि हम दो states मिलके एक agreement कर लें कि हमारा investor आपके मुल्क में आएगा, उसको ये rights मिलेंगे और आप उनको उनके rights को infringe नहीं करेंगे. अगर आप करेंगे तो आपका उसका compensate करना पड़ेगा और आपको उसके ऊपर proceedings में आना पड़ेगा. BITs came into being because उससे पहले ये concept नहीं था. इन्वेस्टर्स के पास दो ही रास्ते थे. अगर कोई इन्वेस्ट करता था वो अपने स्टेट के पास जाते थे कि जी इन्होंने हमारे साथ ज्यादती की, आप स्टेट टू स्टेट इनसे कोई लड़ाई डाल दें. और वो लड़ाई जाती थी ICJ में, क्योंकि उससे क्योंकि मैकेनिज्म था. एक्सेट केम इनटू बीइंग इन 1965. तो उससे पहले डिस्प्यूट सेटलमेंट PCA के थ्रू होती थी, माइदर स्टेट टू स्टेट और अदर रूल्स जो बन जाएं. तो जहाँ तक BITs का ताल्लुक है, it is not, BITs give comfort to an investor essentially कि इनके पास BIT है, I go into this country, I invest. If they frustrate my investment, तो I have an option of taking this state to an international court. BIT ना हो तो क्या होगा? फर्ज करें पाकिस्तान के BIT में, पाकिस्तान में इन्वेस्टर आके वो क्या फ्रेमवर्क देखेगा? दे लुक एट आवर लोकल फ्रेमवर्क, एक अच्छा इन कानून के तहत मेरे क्या राइट्स हैं, मुझे क्या मिलेगा? वो जुडिशल सिस्टम देखेगा, वो देखेगा कि लोगों के केसेस 20-20 साल फंसे होते हैं सुप्रीम कोर्ट तक. मैं यहाँ पे वाई वुड आई इन्वेस्ट इन अ कंट्री जहाँ पे आई एम नॉट श्योर कि मेरी इन्वेस्टमेंट जो है कल को अगर गवर्नमेंट इसको टेक ओवर कर ले तो मुझे अपना हक मिलेगा. सो BITs in a way attract FDI in a way that they give comfort to investors, but in the end obviously it's an obligation, it's a big obligation of the state to carry out. So generally BITs are being phased out because countries are now coming up with their own laws. वो अपने कानून सख्त बेहतर कर रहे हैं, वो अपने प्रोसीजर्स बेहतर कर रहे हैं, वो अपना निज़ाम बेहतर कर रहे हैं ताकि इन्वेस्टर्स को डोमेस्टिकली वो कैटर कर सके इंस्टेड ऑफ गोइंग थ्रू द प्रोसेस ऑफ BITs. जी.
In this one, just a very quick clarification. You mentioned so in the absence of a BIT, can't the investors still have a commercial contract with the government and have an international arbitration clause in that?
वो I was talking about वो BIT के क्यों specific है? They can have commercial contract. Absence of a BIT, they can have an option of a commercial contract. But BIT just gives them a comfort कि अगर कुछ हुआ, additional comfort तो against the state we still have the assurance.
Assalamualaikum, I'm Shajia. I wanted to ask two questions. Basically, एक तो मैं थोड़ी information लेना चाह रही थी about a country कि हमारे country में जो mechanism है कि अब जैसे कि आपने as I was reading your bio कि आपने negotiations में part लिया था जो TCC के साथ हमारे मामलात चल रहे थे. तो do we have a government institution which hire the international lawyers और या फिर हम किसी private firm के साथ contact करती है, यानी हमारी government जब किसी मसले में फंसती है तो उसमें प्राइवेटली जाके किसी फर्म के साथ करना होता है कॉन्टैक्ट, या फिर डू वी हैव अ गवर्नमेंट मैकेनिज्म ऑफ इट? नंबर should I let you know the question? हमारे पास फिल्टर्स क्या हैं करंटली इस तरह के मामला को मिटिगेट करने के लिए? जब मैं पैटर्न देखती हूँ अमूमन जो हमारे केसेस पहले हुए हैं तो बहुत सेल्फिश मूव किया हुआ है कि बहुत सारे लोगों ने जो गवर्नमेंट में किसी टाइम पे मौजूद थे, रिकॉर्ड के केस में भी बलूचिस्तान गवर्नमेंट में, मतलब मैं कहूँगी किसी एक बंदे की सेल्फिशनेस कह सकते हैं, या फिर आप ये कह सकते हैं कि शायद उनकी कम अकली हो या कुछ भी हो, क्योंकि हमें पता है कि हर बंदा हर पर्सपेक्टिव से नहीं सोचता इस तरह के मामला करने से पहले. तो क्या फिल्टर है हमारे पास कि आइंदा हम लोग के पास ऐसे इश्यूज जो है मिटिगेट हो सकें, कि कोई फिल्टर है भी या नहीं है कि बस कोई भी ऐसे उठ के गवर्नमेंट को इस तरह का एक कॉन्ट्रैक्ट साइन कर देगी और फिर हम लोग 20 साल उसको लड़ते रहेंगे? थैंक यू.
पहला सवाल आपका जो था कि जी हम डिस्प्यूट आता है तो क्या होता है और पाकिस्तान क्या करती है, बेसिकली उसके बाद बात है. मैकेनिज्म जो गवर्नमेंटल है ऑब्वियसली वो होता है, ये हमारा जो निज़ाम बना हुआ है, रूल्स ऑफ बिजनेस हैं और सारे प्रोसीजर्स हैं. जब एक डिस्प्यूट आ जाता है तो द फोकल पॉइंट इज़ द अटॉर्नी जनरल ऑफिस, इट बीइंग द लीड एजेंसी जहाँ पे जो डिस्प्यूट हैंडल करती है सरकार के जो सारे स्टेट के जो होते हैं. सो इन द इंटरनेशनल इन द अटॉर्नी जनरल ऑफिस इज एन इंटरनेशनल डिस्प्यूट यूनिट जिसका मैं ही पार्ट हूँ. तो हमारे पास डिस्प्यूट रेफर होता है फिर. सो कोई लाइन मिनिस्ट्री होगी या कोई इस तरह की सब प्रोविंशियल गवर्नमेंट डिपार्टमेंट होगा जहाँ पे डिस्प्यूट आ चुका है, नोटिस आ चुका है और आर्बिट्रेशन का नोटिस एक्सिट को भी चला गया, तब वो हमें इन्फॉर्म करते हैं कि जी डिस्प्यूट लाइव हो गया. सो दैट्स व्हेन वी कम इन. इशू जो है वो ये है कि देखें वी लोकली यस देयर इज़ अ डेर्थ ऑफ एक्सपर्टीज एंड लॉयर्स. बड़े कम है यहाँ, गिने चुने इंटरनेशनल लॉ में काम करते हैं, गिने चुने इन्वेस्टमेंट आर्बिट्रेशन में काम करते हैं, स्पेशली दोज हायर्ड बाय द स्टेट, बड़े कम है. सो एक तो पहलू ये है कि यस कैपेसिटी इश्यूज हैं, दैट इज़ द रीज़न वी हैव टू हायर लॉ फर्म्स. लॉ फर्म्स हायर करने के दो रीजंस हैं. पहला रीज़न ये है कि देखें लॉ फर्म्स हैव एक्सटेंसिव एक्सपीरियंस इन आर्बिट्रेशन. जहाँ पे स्टेट के पास एक्सपीरियंस नहीं है, दे कैन एटलीस्ट हैव समवन ऑन देयर पैनल जो उनका केस आगे लेके जा सके, उसको पता हो केस हैंडल कैसे करना है. दूसरा उसका फ़ायदा ये होता है कि आपकी इंटरनल कैपेसिटी बिल्डिंग होती है. सो अटॉर्नी जनरल ऑफिस का ये फ़ायदा होता है कि जी जब वो डिस्प्यूट आता है वी हायर अ लॉ फर्म, तो लॉ फर्म हमारे साथ काम करती है. सो हमारी इंस्टीट्यूशन कैपेसिटी उस तरह बिल्ड होती है कि वी अंडरस्टैंड अच्छा डिस्प्यूट है, इसके प्रोसेसेस क्या होते हैं, किस रूल के अंदर क्या फाइल करना है, क्योंकि द डिफरेंट लोकल लॉ में तो हम सबको पता है हमने पिटिशन फाइल करनी है, होना है वो होना है. इंटरनेशनल लॉ में देयर मेनी अदर थिंग्स आर कमिंग टू प्ले. सो उसका फ़ायदा भी होता है फाइलिंग का कि हमारी अपनी ट्रेनिंग भी होती है और कैपेसिटी बिल्डिंग भी होती है. दूसरा आपका सवाल ये था कि इसको मिटिगेट कैसे कर सकते हैं. कम्स बैक टू द सेम पॉइंट जो डिस्प्यूट प्रिवेंशन के आते हैं. जैसे इंफॉर्मेशन शेयरिंग है, आई मेंशन कि BOI है. सो BOI बहुत बड़ा इदारा है, बोर्ड ऑफ इन्वेस्टमेंट. दे हैव प्रोविंशियल BOIs. वो प्रोविंशियल BOIs का काम है कि वो नज़र रखें कि उस प्रोविंस में इन्वेस्टमेंट्स कहाँ हुई हुई हैं, कौन कौन इन्वेस्टर काम कर रहा है, उनके कॉन्ट्रैक्ट्स क्या हैं और वो सही चल रहे हैं कि नहीं चल रहे हैं. सो BOI is supposed to be the focal when it comes to these things, because they handle investments, they handle investors. तो प्रोविंशियल काम ये कि प्रोविंशियल अथॉरिटीज़ जब कोई कॉन्ट्रैक्ट साइन करती हैं, BOI को ऑन बोर्ड लें, लॉ डिपार्टमेंट को ऑन बोर्ड लेने के ये कॉन्ट्रैक्ट साइन हो रहा है, उनके साथ बैठें, उनको समझाएं कि ये कॉन्ट्रैक्ट है. आउटसाइड हेल्प ले लें इनिशियली कि जी बेस्ट प्रैक्टिस है दुनिया में क्या है कॉन्ट्रैक्ट की. वो करके आप कॉन्ट्रैक्ट साइन करें इन्वेस्टर के साथ. वो कॉन्ट्रैक्ट डिपॉजिट हो प्रॉपर BOI के साथ जो मॉनिटर कर सके जी इन्वेस्टमेंट चल रही है कि नहीं चल रही. इन्वेस्टर और BOI और प्रोविंशियल डिपार्टमेंट के दरमियान इंफॉर्मेशन शेयरिंग हो कि इन्वेस्टर ने किसी लाइसेंस के लिए अप्लाई किया हुआ है, अच्छा उससे कहा था 1 महीने मिल जाएगा, वो 10 महीने में नहीं मिला, तो समवन हैज़ टू इंटरवीन एंड दैट इंटरवेंशन कम्स either through the BOI or the provincial department. So information sharing is a big part of it. That's how you can mitigate instances of arbitration in the state agency level actually.
Usually it's not the information shared after we are done with the contract. तो जब कॉन्ट्रैक्ट हो जाता है तो तब हम बताते हैं कि हमने इतना का कॉन्ट्रैक्ट किया है. गवर्नमेंट किसी पूछती तो नहीं है ना पहले.
That is the point basically. The contract बन रहा होता है ना, you have to take all the stakeholders on board when you're getting into a contract with the foreign investor.
Is this a procedure कि जब भी गवर्नमेंट ने कोई भी इन्वेस्टमेंट लेनी है तो उसने इन्वॉल्व करना है BOIs को, या ये सब को लोग हमारा मौजूद है?
करते हैं, बिल्कुल करते हैं.
या फिर उनकी मर्जी है वो करेगा?
नहीं वो करते हैं. जैसे हमारे पास भी जब कोई कॉन्ट्रैक्ट्स हमारे पास भी आते हैं, दे गेट वेटेड बाय द मिनिस्ट्री ऑफ लॉ एंड जस्टिस. सो एवरी कॉन्ट्रैक्ट द स्टेट एंटर्स इनटू, वो मिनिस्ट्री ऑफ लॉ एंड जस्टिस उसको वेट करती है. उसका डिस्प्यूट सेटलमेंट क्लॉज अटॉर्नी जनरल ऑफिस वेट करता है. सो दैट्स नॉट बिकम कॉमन प्रैक्टिस वेदर इट बी एग्रीमेंट्स एटलीस्ट फेडरल लेवल पे ही होता है. प्रोविंशियल लेवल पे ऑब्वियसली उनका अपना प्रोविंशियल डिपार्टमेंट है और वो सारे वेटिंग करते हैं. इशू वेटिंग का नहीं है, इशू ये है कि आप जो कॉन्ट्रैक्ट वेट करें आपको पता हो आप ऑब्लिगेशंस अपने ऊपर ले क्या रहे हैं. दैट्स वेयर द ट्रेनिंग कम्स इन. कि आप जो कॉन्ट्रैक्ट इन्वेस्टर के साथ साइन करें आपको पता हो कि अच्छा हमारा ये इन्वेस्टर इस मुल्क का है, उसकी BIT हमारे साथ साइन हुई हुई है, तो हम ये देख के करेंगे, हम ये ऑब्लिगेशन लेंगे, इस तरह करेंगे. कॉन्ट्रैक्ट के अंदर क्या चीज़ डाल सकते हैं, कहाँ पे हम इन्वेस्टर को भी कहें कि जी आपने ये काम करना है, ये काम नहीं करना. सो दैट्स व्हाट बेस्ट प्रैक्टिसेस इज.
So do you think before the case जब हमारा स्टार्ट हुआ है, जब वो कॉन्ट्रैक्ट बना था, that was a failure कह सकते हैं या फिर laziness कि वहाँ पर आई थी, किस तरह से ये इतना बड़ा कॉन्ट्रैक्ट?
नहीं रिकॉर्ड डेट असल में रिकॉर्ड डेट
ऑनेस्टली जो हम उसको सिंपल फैक्ट जब पढ़ते हैं कि जब जितना कुछ हम उनको देने की तैयारी कर रहे थे तो वो कोई बच्चा भी कहेगा इतना नहीं लेना, तो ये कैसे हुआ? मैं इस पे बहुत हैरान हूँ.
नहीं देखें रिकॉर्ड डेट इट स्टार्टेड इन 1990s टेक्निकली. कॉन्ट्रैक्ट जो पहले हुआ था वो 93 में हुआ था. तो दिस हैज बीन गोइंग ऑन सिंस द 90s जो कॉन्ट्रैक्ट हुआ. देखिए पॉइंट कॉन्ट्रैक्ट साइन होता है. कॉन्ट्रैक्ट मसला कॉन्ट्रैक्ट आपने जब एंटर कर लिया ना, सो यू अडर टू द कॉन्ट्रैक्ट. अगर आपने कॉन्ट्रैक्ट से आप खुश नहीं है ना तो आप इन्वेस्टर को बुलाते हैं और आप वो कॉन्ट्रैक्ट अमेंड करने की कोशिश करते हैं. जी हम समझते हैं कॉन्ट्रैक्ट में ये मसले हैं, वी फील वी वोंट एबल टू फुलफिल सम ऑफ थिंग्स, आप इसे अमेंड कर लें. बट यू डोंट डू इज यूनिलैटरली टर्मिनेटेड एंड से अब हम नहीं करेंगे. सो द पॉइंट इज यू एंगेज द इन्वेस्टर. कॉन्ट्रैक्ट जरूर करें बट कॉन्ट्रैक्ट की ऑब्लिगेशन जो आपने अंडरटेक कर लिया उनको आप यू टेक देम ऑन एंड यू फील यू कांट अंडरटेक ऑल दोज ऑब्लिगेशंस, आप इन्वेस्टर को बिठाएं, यू साइन अ न्यू कॉन्ट्रैक्ट. Record is a separate case. It's been talked about, written about everything. So I won't get into it. But what happened. But in the end of the day, when a state enters into contracts, it has to adhere to its obligations. Simple si baat.
Should be little more vigilant.
Or be more vigilant. Yes. Thank you. Thank you.
Thank you, Mr. Zahir, for a very insightful lecture. Now we will have a 15-minute break till 12:10, after which we will have a lecture by Mr. Ali Zahid Rahim. on international institutions of arbitration. Thank you very much. Hope you enjoyed the break. Our second lecture of the day shall be on international institutions and arbitration. This lecture shall be conducted by Mr. Ali Zahid Rahim. Mr. Ali Zahid Rahim is currently a partner at Access Law Chambers, Lahore. He is an international arbitration expert with a particular interest in investor-state dispute settlements and investor treaty arbitrations. He has also been involved in international commercial arbitrations held before ICC and LCIA, and in domestic arbitrations under the Arbitration Act 1940. He has extensive experience representing parties in complex cross-border international disputes involving both public and private international law issues. His work experience includes 2 years at the World Bank's legal department, called the Legal Vice Presidency then, at its headquarters in Washington, D.C. as a counsel. Ali completed his LLM from UC Berkeley School of Law in 2008 and his LLB from Pakistan College of Law in 2004. Sir, the floor is all yours.
Ji, Assalamu alaikum. And first of all, many thanks to the Islamabad Policy Research Institute and Mr. Rana Sajjad and his organization for inviting me today to speak about international institutions in arbitration. So I believe I have an hour, and in this hour, while I was preparing my own presentation, and my presentation is primarily going to focus on ICSID, the International Center for the Settlement of Investment Disputes, which is a World Bank organization. I came across the Secretary General, who is Meg Kinnear. She's a Canadian who's been at ICSID since 2009. So while preparing this presentation, I came across her presentation. She travels the world to apprise people of ICSID, its mission, its organization, and what it does. So I'll tap into that resource. And there's a sort of disclaimer at the end of the presentation which says it can be used for educational purposes. So my presentation is going to be fairly brief as I explain what ICSID is. Then I'm going to speak about some of the procedural aspects of what an ICSID arbitration is, and then we can open the floor up to questions. So let me begin. So ICSID, as we know, is a key international institution in arbitration. Zuhair also spoke about Pakistan's experience recently with 2 big ICSID arbitrations. So I think historical context and history is very important when we speak about institutions. And so it's important to situate ICSID, which is one of the 5 World Bank entities that comprise the World Bank group. And again, bear with me as I explain some of this history. So after World War in 1944, at the United Nations Monetary and Financial Conference, commonly known as Bretton Woods. Bretton Woods is a place in New Hampshire, USA. The Allied powers, basically led by John Maynard Keynes, the eminent economist, they came up with the idea of the World Bank and a specific organization, which is the first World Bank entity, called the International Bank for Reconstruction and Development. So IBRD was conceived as a result of the changing power dynamics at the time, and basically they required an entity to reconstruct war-torn Europe. So that's how IBRD came into being in 1946. So in 1946, it began its operations, and it, as I said, is the first of 5 World Bank entities as the group exists today. Secondly, the IFC was formed in 1956, almost 10 years later, IFC, as some of you may know, is the private sector arm of the World Bank, and it finances, supports private entrepreneurship and private sector development in developing countries. In 1960 then, the International Development Association came into being as the third organization comprising the World Bank Group. And the IDA has a long history with Pakistan in specifically, because Pakistan is still classified as a low-income, low to middle-income country. And IDA primarily lends to countries like Pakistan, and the financing terms are on a concessional basis. This is also important as you try to understand institutions. You must know that the World Bank Group has historically always had an American president. And so this is a tacit understanding again between Europe and America, that the sister organization, which is the International Monetary Fund, also created as a part of the Bretton Woods Washington Consensus, as it's known. So IMF is always headed by a European, and the World Bank is always headed by an American. So often one overlooks that fact, but I think it's important to sort of put this in context. So this is again one of the five institutions that comprise the group. I mentioned IDA last, that was conceived in 1960, and then it came the turn to basically come up with an international treaty, because the ICSID Convention of 1966 is an international treaty. It provides international facilities for the conciliation and arbitration of foreign investment disputes. So ICSID was conceived over, let's say, a 3-year period, and I'll go into some of that history. It's a very interesting chapter in world affairs as the process of decolonization unfolded. So the ICSID Convention is also known as the Washington Convention. And finally, in 1988, the World Bank established the Multilateral Investment Guarantee Agency, which provides 3 key services. It provides political risk insurance for foreign investment. So ICSID and MIGA have a sort of direct nexus, because both are focusing on foreign investment, and MIGA provides technical assistance and other dispute mediation services. So next we'll move to the origins of ICSID. As I said, this was a 3-year process negotiating that particular treaty from 1962 to 1965. So again, history is very important as you try to understand institutions. And so in the early 1960s, the World Bank was being urged from various sides to take some action to help overcome the political risk obstacle, which was inhibiting the flow of private investment from the rich to the poor countries. So in the 1950s, there were a series of cases dealing with hydrocarbons and petroleum concession contracts. And during that time, it was felt that, these newly independent countries in the Persian Gulf primarily, so they faced a lot of issues with nationalization of some of these assets and other, takings as far as foreign investment is concerned. So the developing world, the rich countries at the time, they wanted some kind of mechanism to protect big capital, big corporations who were operating in some of these countries. And OECD, which is the Organization for Economic Development, it's an organization that's worked on many different areas. So they basically, there were 2 approaches. One approach was the direct approach, which was being represented by the work of OECD, and they wanted a code of good behavior. So the emphasis at that point in time from the perspective of rich countries was to have a multilateral agreement, a multilateral treaty of sorts that would protect the rights of foreign investors. And on the other side, we had these newly formed nation states. The decolonization process had begun, and they were very sensitive to protecting their sovereignty and sovereignty, especially as far as their natural resources are concerned. So the other proposal was that there were various proposals, not one but many, for the multilateral insurance of investments against expropriation and other political risks. The management of the World Bank, and one World Bank lawyer in particular, his name is Aaron Broches, and we'll spend a few minutes talking about this man and his career at the World Bank. They sort of realized that we can't enter into a multilateral investment treaty to protect foreign investment at the time, because many of the newly formed developing countries were strongly opposed to some of the proposals being furnished by OECD and some of the other rich nations at the time. So a sort of balancing act had to be done, and basically they thought that settlement of investment disputes, the World Bank should play a role in resolving these disputes, and arbitration became the key means to settle some of these big investment disputes. Aaron Ronnie Broches was a Dutch lawyer who was part of the Bretton Woods meetings also in 1944. So he had that particular experience, and later he joined the World Bank and played a pivotal role in forging ahead with the bank's idea of the establishment of a standing multilateral foreign investment dispute settlement mechanism. And again, I would just sort of briefly like to point out the UN General Assembly Resolution 1803, titled Permanent Sovereignty over Natural Resources. This was 12th January 1962 that this resolution came about. And paragraph 4 of the declaration is important, as it sort of recognizes the newly formed nation states' right, permanent sovereignty over natural resources, but it again sort of mentioned in the context of nationalization, expropriation, with those cases that concerned everyone in the 1950s, that however, upon agreement by sovereign states and other parties concerned, settlement of the dispute should be made through arbitration or international adjudication. So previously, this is something that Zuhair also mentioned, that some of these disputes involving foreign investors and nation states, the diplomatic sort of missions, the governments of the day on a state-to-state level would engage with each other to resolve these disputes. So this is known as diplomatic espousal. And that was the sort of go-to method to resolve some of these disputes. But after seeing the experience of the 1950s, many sort of countries thought that arbitration or in sort of an arbitration with institutional arbitration or ad hoc arbitration makes sense as far as some of these disputes are concerned. So this is that particular resolution. And as I said, this was done in 1962 and right before ICSID was formed. So this is the context in the early 60s in which it was thought that it makes sense for the World Bank to intervene and provide a facility to settle these international disputes. So this is Aaron Ronnie Broches. He had a long and fruitful career. Was born in 1914, passed away in 1997 in Washington, D.C. Became the Assistant General Counsel of the bank in 1951. 7 years previously, as I said, he was part of the Dutch delegation that negotiated the articles of agreement for IBRD, so had that experience as a young 30-year-old. And often you'll see in international law, and there's a session on careers in international law, you'll see people in their late 20s to early 30s benefit from working in an organization, and then they have gone on to do great things. And this is true for many international institutions. So, when we speak about international institutions and arbitration, personalities are important, and in my opinion, I think Aaron Broches was someone who in many ways single-handedly achieved many things as far as this sort of new regime is concerned. And there's the other very famous international lawyer, Ibrahim Shehata, who worked again at the World Bank from the 1970s onwards to the 90s. He was someone who played a pivotal role in making MIGA in 1988. So we have these strong personalities in these international institutions that left a very deep mark at the institutional level. So as you can see, I don't know if you can read this clearly, but this is from an ICSID newsletter published in 1997, and this is his obituary written by some of his colleagues. So in 1956, he was promoted to the role of Director of the Legal Department and Associate General Counsel. In 1959, he became the General Counsel, which is the top sort of Chief Legal Officer, head of legal position at the bank. And during these years, he adopted a pragmatic approach, given all the discussions going on, and these are very sort of contentious discussions between the rich countries and the newly decolonized independent nations. So his colleagues and Aaron Broches developed the legal foundations for the operations of the bank, pioneering approaches to such important issues as the governing law of bank loan agreements. They were prominently involved in building a World Bank group working on the articles of agreement of its first affiliates, the IFC and the IDA. So this is Aaron Broches. If you want to know more about how ICSID came into being, the World Bank's website has an archive section, and it has all these transcripts of his interviews at the time. And this is their oral history program, which is very useful. And as students, I would highly recommend that, again, if you want to learn more about an institution, there are all kinds of incredible resources available on the internet for free. So these transcripts, again, provide the context and provide historical insight as to how these institutions were made back in the 60s. So just a year after the establishment of the IDA in 1960, Broches and the then president of the World Bank broached with the World Bank's executive directors the idea of setting up a further affiliated institution, the center that became ICSID. And I don't know if you're aware, but the World Bank, all the member governments of the World Bank have executive directors. That's the top position held by a country. And from Pakistan, we've had very prominent bureaucrats, lead the banks, the Pakistan's mission at the bank, and perform this role as the executive directors. So by providing an international forum for the conciliation and arbitration of investment disputes, it would help to promote the flow of private foreign investment, an objective of special concern to the bank given everything that was going on in the world at that point in time. There followed successive drafts of the convention that Broches again negotiated with member governments. A final text was approved by the executive directors in March 1965 and opened by them for signature and ratification of member governments. And in accordance with its terms, the ICSID convention came into force 1 month later. And again, Pakistan was among the top, the first, I would say, 20 countries to sign the ICSID convention. You need 20 countries to sign a treaty for it to come into force. And so Pakistan was one of the earliest signatories to the ICSID convention. So ICSID is led by an administrative council, and it held its inaugural meeting in 1967, and Aaron Brocious became the first Secretary General of the Center, authorizing him to combine that function with continued service as General Counsel. So Aaron Brocious remained Secretary General of ICSID for the next 13 years till 1980, and in that period he oversaw the preparation of the ICSID regulations and rules and model clauses, registered the first ICSID cases, that was back in 1972, launched the Center's investment law publishing activities, and introduced the ICSID additional facility rules. And in the meantime, he sort of rose through the ranks to become Vice President and General Counsel. So these are some of the member state parties. Again, I think we've gone through this, and in that other ICSID's own presentation, I can go over some of the organizational aspects of this organization that's become over the years, especially in the last 25 years, it's one of the most powerful international institutions when it comes to international investment law and investment arbitration in specific. So as far as the signatories to the ICSID convention, currently there are 158 countries who've signed. There are another few countries who've signed recently but haven't ratified the convention. As I said, Pakistan ratified the convention on 15th October 1966, one of the first 20 countries to basically accept ICSID and sign off. So here I would like to point out, and this is something that you guys need to think about, that India never signed the ICSID convention. And as you heard yesterday and some of it also today, there's often, this controversy or debate about entering into bilateral investment treaties or becoming a member of ICSID in order to then attract foreign investment. But India never signed the ICSID convention consciously. India, in fact, attracted more than $85 billion last year in FDI. So something to think about as you understand what the current debates are when it comes to BITs and institutions like ICSID. Canada, for example, became a member of ICSID in 2006. And there are many sort of capital exporting countries who consciously sort of chose not to become a member till a very long time. So this is how Pakistan in 2011, this is the Arbitration International Investment Disputes Act 2011. And this is also important that then, even though we ratified the convention in '68, it was only in 2011 with the help of there's a US government commercial law program, and basically they were providing technical assistance to the government of Pakistan in 2011. And one of our very sort of famous arbitrators, prominent international lawyers, Makhdoom Ali Khan, he was a key figure in ensuring that Pakistan passes domestic legislation to implement the Washington Convention. And alongside the Washington Convention, as you know, Pakistan also passed a domestic statute to implement the New York Convention of 1958. So when it comes to international arbitration in international institutions, these two conventions, treaties are of central importance. So this is the governance structure of ICSID. The World Bank, I don't know if you guys are aware, but they have a new Sikh origin American president who will take over from David Malpass in the next few weeks. And I'm not sure, he may have already taken over. But by virtue of being the president of the World Bank, as I mentioned, he automatically chairs the Administrative Council of ICSID. So this is the Administrative Council. We've got the President of the World Bank as the chair of the Administrative Council. All treaty members are part of the Administrative Council and can freely participate in all its meetings. This is the Secretariat, headed by a Secretary General. I mentioned Aaron Broches as the first. Meg Kinnear is completing her 16th year I think this is a 15th year at the World Bank. And during the last 14 years, there's been an explosion of ICSID cases the world around. And so Meg Kinnear is another key figure as far as this organization is concerned. And you can find, as I said, I came across that presentation in which she explains the institution. There's other sort of information and her videos available on YouTube if you want to know more about ICSID, from the horse's mouth. So Meg Kinnear, the Pakistan government also had to deal with her extensively during the recent two big disputes, Karke and Recordec. So the governance structure, as we continue of ICSID, the ICSID staff, and there's a staff of around 70 people. And in terms of international careers, and this is something that we'll discuss later perhaps, but they offer virtual internships, externships. So there's a lot of information. They have a new revamped website. And so for, young lawyers who want some experience, you should explore their opportunities, which are advertised freely on the website from time to time. So the Secretariat consists of around 70 people, and a lot of lawyers work there. When I joined the World Bank in 2008, I had the sort of option to join ICSID at the time, which I consciously did not. I opted for another assignment my first year, and the second year I was posted somewhere else. But ICSID has a lot of young lawyers who perform various roles, and among those roles they sometimes provide secretarial services to an ongoing arbitration and help the tribunal with many administrative things. So ICSID has a journal, it's called the Foreign Investment Law Journal. It's also not available freely, but I mean many articles are there explaining the investment, the international law of foreign investment, and it's a quality publication where a lot of eminent academics, practitioners contribute to it regularly. So after coming into existence in 1965-66, it started operations. The first sort of case was registered in 1972. And mostly people talk about bilateral investment treaties in ICSID, but one forgets that ICSID can also be the dispute resolution mechanism in an international investment contract. And so, in that context of all those oil cases in the Gulf, many Western practitioners from rich countries made contracts which particularly mentioned ICSID being invoked in the face of a foreign investment dispute. And so you see that in the from 1972 till 1989, all these disputes that ICSID handled were emanating from international investment contracts rather than any international investment agreement or an international investment treaty. The first case under an international bilateral investment treaty was in 1989. It was against Sri Lanka, and that kind of, becomes historically a key moment in time in 1989, when then subsequently the explosion happened, and countries entered into lots of BITs, and then in the early 2000s, late 90s, the ICSID caseload started increasing drastically. And in 2021, 66 new cases were registered before ICSID. And I mean, that's just been the trend ever since. Here I should also mention that some of the first ICSID cases being managed by ICSID emanated from the North American Free Trade Agreement. And these were seminal cases between the United States and Canada primarily. They developed a lot of jurisprudence. Some of the precedent is cited routinely in some of these cases. These were in many ways some of the pioneering cases under that particular North American Free Trade Agreement. So this is the accelerated growth in ICSID, and if you see this pie chart, it's interesting that since the 1990s, 60% of ICSID's caseload involves bilateral investment treaties. Then, some of the host states, the capital importing countries, have domestic foreign investment law, which can be invoked by foreign investors. You see NAFTA there as a key instrument. And as I said, people often forget, but investment contracts between the investor and the host state often include ICSID. And I think there was an excellent question earlier in the session also about what governments can do to ensure that contracts are negotiated and executed with proper due diligence and care. So often, as I said, bilateral investment treaties overshadow the use of international investment law dispute resolution mechanisms, but investment contracts are even, I would say, as potent and with real consequences. So if you look at the ICSID website, they have an excellent case database. If you search by Pakistan, you will come across this list. And as you will see later on, when it comes to South Asia, Southeast Asia, Pakistan is among the top countries that has been sued before ICSID the most number of times. And this history in particular is, it has many lessons for Pakistan. I recently wrote an article on Pakistan's experience with investor state arbitration, which was published in PLD. And basically in that article, I contrast the period from 2000 to 2010 with the period 2010 to 2020. And I'll just summarize some of my analysis. And basically, when we had Makhdoom Ali Khan as the Attorney General for Pakistan between 2001 and 2007, there were 4 ICSID cases, as you will see, filed in 2002, 2003. And these were, even though, I don't know if you've come across this much publicized interview given by the Attorney General after he had stepped down in 2007, Mr. Khan, in which he explains that he did not know what ICSID was when he was the Attorney General. And at conferences also, at that particular conference, I think he loves telling this story about, he had to Google what ICSID was, and he had no knowledge whatsoever when he received the letter from the Ministry of Law, and the Secretary of Law called him at the time and said, look, we've received this notice, I don't have any clue, what are we supposed to do? And that's how Mr. Khan then embarked on his journey to understand international law to then effectively manage these disputes. And as I said, he was very successful in managing them efficiently and in resolving them in quick time. And I don't know if you're aware, Makhtoom Ali Khan sits on ICSID panels regularly. He's one of 4 people nominated by the government of Pakistan on ICSID's panel of arbitrators and conciliators. And he is just someone who has the most knowledge and experience when it comes to international arbitration. So from 2000, that first decade till 2010, Pakistan managed to deal effectively with some of these disputes. Later on, when he left, one of the sort of interesting features about his long tenure at the Attorney General office was that he could not build any capacity. He could not build any institution within that office that could sort of effectively deal with such cases. And then you see Pakistan completely adrift in the early 2010s when Karke was filed, for example, and when the TCC case was filed. So some of the decisions, if you read those awards and if you go through the early history, it's quite evident how clueless we again were after a good period in which Makhtoom Saab sort of spearheaded those disputes. So again, as far as Pakistan is concerned, a lot to think about and learn from as far as these disputes are concerned, which are high as far as this region is concerned. So again, ICSID, there's the treaty. Of course, everything emanates from that particular treaty, the Washington Convention of 1966. But then the way a dispute progresses before ICSID has to do with its certain rules and regulations. And you should be aware that it took the World Bank and ICSID involving the Administrative Council a good period of 5 and 6 years to update its rules recently. And so from 2015-16, this effort started. And the context of this sort of whole exercise leading up to the new 2022 rules and regulations is that as a result of those first wave of cases before ICSID, there was a lot of backlash by aggrieved states. There was a lot of backlash by participants in the system. And, there were issues dealing with costs, there were issues dealing with time, with efficiency, and most importantly with the arbitrators adjudicating on these disputes. And so ICSID spent a lot of time to update and modernize its framework, leading to the ICSID Arbitration Institution Rules of 2022, the arbitration rules and the conciliation rules also. So again, there's a lot of information as far as this process is concerned. And again, we don't know if Pakistan actively provided any input or was an active participant as far as these drafts were concerned, because there is no information. And Pakistan, as you know, being a member state, it did have a seat on the table, but no one knows if he ever sort of meaningfully engaged with some of these rules. The ICSID arbitration procedure, I maybe quickly use that other presentation to go over how an arbitration commences, how it's pursued, and the various steps involved. But again, the convention governs, and then the detailed arbitration rules. So this is also from ICSID's website. This is a neat chart that kind of explains how an arbitration commences. It commences with the request, the requesting party, the claimant filing a request for arbitration. And here I would like to point out that historically, when the TCC case began in late 2011, the claimant TCC filed two claims, one against Pakistan and one against the government of Balochistan before ICSID. So when ICSID, and they have this internal screening and registration of the request for arbitration, they refused registration of that claim against the government of Balochistan because under the treaty, Pakistan had not notified the government of Balochistan as a state instrumentality, as a state agency. So ICSID returned that claim and said, look, you've come here, you could not have come here, and we cannot proceed with this request for arbitration. And so I don't know, I mean, if you've read the TCC award, you would know that alongside that particular ICSID arbitration, TCC sued us under the joint venture agreement before the ICC. And so that was a parallel arbitration, and there's a lot of literature on parallel proceedings. So in terms of ICSID doing its job, it refused registration in that particular instance. Then another key phase of an ICSID arbitration is deciding upon who to choose, who to pick as arbitrators. And again, I think TCC, that's a very useful sort of case in which Pakistan chose Lord Leonard Hoffman, retired judge of the UK Supreme Court. I mean, there was no UK Supreme Court at that point in time, but basically a judge of great repute. And I'm sure in your commercial law, contract law classes, you've read cases authored by Lord Hoffman. But in Pakistan's case, and this is something that is often talked about with people who've been involved in this arbitration and generally the world over, this choice of Leonard Hoffman back in 2012 is something that's often talked about. And so Pakistan picked Lord Hoffman. The claimant TCC picked Stanimir Alexandrov, again a very well-known entity as far as investment arbitration is concerned. And the ICSID tribunal then appoints, so there are two party appointed arbitrators, and then there's the chair which ICSID appoints. And so we had Klaus Sachs, a German national, a German lawyer, as the president of that particular tribunal. In Karke, Pakistan lost the opportunity to appoint someone, and that is the other sort of strange facet of that particular period and Pakistan dealing with these disputes, that we had a full team in place for the TCC case. But I mean, it's quite obvious that there was zero information sharing between the Attorney General's office and that other team, because we missed the deadline and recommended retired Pakistani judges later in the process, and the World Bank replied simply by saying, we can't do anything because this is what the treaty says about appointment of arbitrators. So in Karke, we ICSID appointed an arbitrator on Pakistan's behalf. As far as live issues before ICSID is concerned, as I mentioned, that whole effort to modernize and make new rules took 5 years. But then, because of many criticisms of the system, ICSID is currently working on a code of conduct for its arbitrators. And again, you should sort of look into the United Nations Conference on International Trade Law. It has a website, it has a working group 3 that's been in existence and dedicated to reforming investor-state dispute settlement, and it has a lot of resources. So again, this has to do with context and history, that as there was an explosion of all these investment treaty cases in the early 2000s and the early 2010s, there were a lot of meaningful criticism of the system. And so UNCTRAL made this working group to somehow address those concerns. And institutionally, ICSID is also a key institution that's focusing on reforming its own systems and procedures. And so the code of conduct for arbitrators is a very long, I would say it's a long time coming. There were many real issues of conflict of interest, of appointments, of being a lawyer one day and then appearing as an arbitrator the other day. So a lot of effort and time has gone into coming up with a code of conduct that's acceptable. ICSID facility rules alongside the main ICSID arbitration rules and the convention. ICSID also provides what are known as the additional facility rules. These have also been modernized, so they also are of 2022 rather than 2006. And what this sort of regime does is that nationals, foreign investors, and countries who are not part of the ICSID convention, they can utilize this mechanism and let ICSID administer these kind of disputes. Apart from these additional facility rules, ICSID also has new rules on fact finding. So if parties want ICSID to do a fact finding exercise, there's an expropriation, there's a site visit. If people don't want to initiate full-scale arbitrations, it provides facilities to carry out that function. And alongside, if you look at the ICSID website, if you look at the rules modernized in 2020, ICSID now also provides mediation services. Lastly, when you compare institutions in international arbitration, obviously ICSID handles more than 70 or 80% of foreign investment disputes, but international investment arbitration is contrasted with international commercial arbitration. I will not spend much time on this distinction or explain the sort of nuances of what an international commercial arbitration entails or the substantive law of international commercial arbitration, but I would just like to cite from an institutional point of view this particular survey carried out by Queen Mary University in London and the very famous law firm White & Case in 2021. In this survey, basically, some of the key institutions that you may have heard are the International Chamber of Commerce. Obviously, the International Chamber of Commerce was formed in the 1920s, and it recently had its 100th anniversary. And the largest number of, let's say, international arbitrations are held under the ICC. So ICSID also has arrangements with all of these institutions, but ICC arbitration is a particular kind. Again, Pakistan state-owned entities have been involved in ICC arbitrations for a very long time, and these are primarily completely confidential. Because, as you know, one of the main sort of features of international arbitration is confidentiality among parties. So people often invoke ICC arbitrations. There was mention of some power sector cases, and in many of the current power sector cases, we have ICC arbitration as the dispute resolution mechanism. And often the seat of arbitration is, let's say, Islamabad or Lahore, but we have the ICC rules govern. So that's what Pakistan does. Many state-owned entities say that, look, this arbitration will be governed by the law of Pakistan. The seat will be a city in Pakistan, but we'll use the ICC rules to carry out the arbitration. Then there's and in international arbitration, so Asia is the hub of international arbitration, and as you understand institutions, as you learn more about international arbitration, you will realize that all the sort of big names in arbitration, they've relocated from, let's say, New York, London, Paris, and they spend a considerable amount of time in places like Singapore and Hong Kong. So Singapore and Hong Kong, I mean, you make a list of 20 people who have the most experience in international arbitration in the last 40 years, and you'll find they have an address in Singapore and Hong Kong. So, and especially when you look at careers in international law, don't limit yourself to these Western capitals. Look at Asia. As I said, the most number of disputes are now, with Asian parties. So the Hong Kong International Arbitration Center is a very famous international arbitration center. The LCIA, London Court of International Arbitration, it also has an Asian chapter. And recently, China International Economic Trade Arbitration Commission has also been identified in this particular survey as an institution that carries out a lot of international arbitrations. So here, lastly, you'll see this particular chart. These are all the acronyms for these other very famous, most often used arbitral institutions. And you'll see the ICC has a lot of volume when it comes to international disputes. But in the last 3 years, ICC is facing competition from other venues. So lastly, I'll just conclude and say that, as far as international arbitration and institutions is concerned, it's a big industry now, international arbitration, and some of these institutions have been around for, I mentioned ICC for 100 years, some of the others for about 40, 50 years. They've got a whole track record of administering, managing cases, and as people interested in international arbitration, young lawyers, students, it doesn't take much for one to figure out the lay of the land if you try hard enough. Every resource that you can think of is available, and you could start by looking at the ICC website, some of the other institutions' websites, and there is a lot of information. So, I mean, there were many concerns about transparency when it comes to international arbitration, but even ICC now provides some limited information about state-owned parties, for example, being involved in an arbitration, and other sort of sector-wise breakdown of oil, gas, and mining sort of arbitrations, or services industry arbitration. So this was my take on institutions and key institutions in arbitration. I did not get a chance to go through that other excellent presentation prepared by Meg Kinnear, But if you want to know more about ICSID, right from the horse's mouth, that is available online. It dates back to 2019, but it very neatly explains the ICSID process and how an ICSID arbitration, is managed. So that's all from my side. I can answer any questions if anyone has any.
My name is Arvind, and my question is कि हमने कल भी देखा और आज भी पढ़ा है कि Pakistan has always been one of the front runners signatories of the international trade agreements, और it has done us wrong. और probably हम ये show up करने के लिए कर रहे थे कि हमारे पास investors के लिए एक बहुत अच्छा legal framework है और उनके interest protection है. तो मेरा ये क्वेश्चन है कि इसकी वजह से हमें कोई इतना फायदा नहीं हुआ. क्या हमें लेकिन जब हम एज पाकिस्तानीज वी सी कि देयर इज अ लॉट ऑफ करप्शन, इनकॉम्पिटेंस, इनएफिशिएंसी और सिस्टम इज ऑलमोस्ट ब्रेकिंग डाउन, और शुड वी क्लीन आवर होम फर्स्ट एंड बिफोर होस्टिंग गेस्ट्स फ्रॉम फॉरेन. और इसकी एग्जांपल मैं देता हूँ चाइना और इंडिया कि उन दो कंट्रीज़ ने बहुत लेट ओपन अप किया था अपने आप को और आज वो हमसे आगे. और एक और मेरा क्वेश्चन ये है कि ये जो बहुत ज़्यादा ये इदारे जो हैं ये वेस्ट सेंट्रिक हैं, और वाई वुड द वाटर सोर्सेज बिकम सक्सेसफुल एंड बिकम अ कंपटीशन फॉर दैम?
ये तो आपका बहुत इज अ वेरी यंग प्रोफेशनल वे, आपका एक सिनिकल व्यू है टू थिंग्स, बट आई मीन you have to understand that Pakistan's been a very important member of the international community, signing these treaties at that point in time. मैंने आपको वो historical पूरा context बताया है जिस में Pakistan chose to participate internationally. It's played a very important role in many UN initiatives. So we were the front runners in many different initiatives. Many key UN documents, Pakistan, you find them again being the front runner. So there's no harm in engaging with the system that we have. Yes, obviously, I mean, as things unfolded, और ये काफ़ी एक unconsciously एक पूरा ये process unravel किया है in the 90s, because आपको याद होगा या आपको पता होना चाहिए कि 1990s में the reason why Pakistan came to sign कोई more than 50 plus BITs was कि कोई जाता था बाहर किसी दौरे पे तो वो कहते थे कि जी एक फोटो ऑप और ये सामने एक बिट पड़ी होती थी, वो जो एम्बेसडर या कोई और लीडर जाता था हमारा वो साइन करके दे टेक अ फोटोग्राफ and then come back, and this was true for all developing countries. इसमें कि Pakistan wasn't the only country to do that. So वो फिर the rest of the history, when they started biting these bits, that's when countries like India and some of the other nations sort of did a lot of thinking, and then they put the brakes on. So इधर अभी debatable है कि हम किस stage पे हैं. So, but I mean, engaging meaningfully with international processes, that's 100%. Pakistan is holds a very key position in the world, and it should continue to engage.
Should not become more exclusionist and inward-looking and clean our house.
कर नहीं सकते ना, वो तो obviously करना ही है. House clean को तो there's no debate about it. Obviously वो तो सारों के सामने ही है कि हाँ. Yeah, as I said, बिल्कुल, that's the current debate. There's a very sharp, जब हम polarization करते हैं, बात करते हैं in politics, तो जो इधर polarization है between proponents of ISDS and the other sort of people who've had bitter experiences, yes, there are great arguments on both sides, which one first must understand to then make sense of what's happening.
Assalamualaikum. My name is Mohammad Faisal Yad from Nash University. So my question is related to the international public policy, because as we have seen, if an award is rendered and it is against the public policy of our country, then they have the right to reject that award. But the other party can go to the other country in which the party have the assets to enforce that word. So my question is that if the party have the assets in only one country and it's against the public policy of that country, but we also have an emerging concept of international public policy. So I want your word that how much we have grown in that international public policy principle, and also we have seen in the commercial arbitration that if matter include the corruption, then it is a non-arbitrable. But in the said because it itself involve a country, so are the matters of the corruption also arbitrable under the Excel or not? Thank you.
दोनों बड़े अच्छे सवाल है. जो पहला सवाल है that's more to do with post award remedies and enforcement, attachment. These are highly complex cross jurisdictional matters, and even if, let's say, there's an exit award, you may think it's against your public policy. The convention clearly says that all member states have to implement it in their country. So if, for example, Karke or TCC were to come here with that award in their favor, with the 2011 Act, we've implemented the convention. Then the High Court, where they would, file that award to enforce, I do not see how they would resist that. I mean, under the New York Convention, there are specific grounds of public policy. There's a specific article that has written, people have written about it extensively. There are sort of grounds to resist based on those reasons. But that's the, from an institutional perspective, ICSID is a self-contained system. And as I said, if you've ratified the convention, if you've implemented it domestically, then you have no choice but to implement those awards. So you may be able to delay them. Judges here may not know the full extent of our international law commitments, but that's what the law says. As far as your second question, can you remind me of your second question? Yeah, corruption. That's excellent. Again, a very sensitive topic that people, engaged with corruption allegations. And there have been many awards recently. There have been awards against Bangladesh. In Karke, obviously, there were corruption allegations. And there's speculation that the matter was settled because Pakistan unearthed some corruption that the investor could not refute. TCC, I mean, once the hearing on jurisdiction and liability was over, it sort of followed a whole 2-year process of dealing with corruption allegations. And so international investment tribunals, currently there's a very high bar that a state has to cross as far as proving corruption. And again, it's I mean, in many people's views, it's next to impossible to prove corruption when it comes to these big intractable disputes. And again, I think you should note this down. There's this news organization called BuzzFeed. So many years ago, about 5-7 years ago, there was this investigative journalist called Chris Hamby. He did a 3-part series on investor-state arbitration. And the main sort of focus was that, these big corporations are involved in big projects all over the world. And each time, they involve in corruption or there are allegations of corruption, they file these claims to sort of tackle those real, very serious allegations under domestic law, plus, other instruments such as the Foreign Corrupt Practices Act, the Anti-Bribery Act, etc. So do, by all means, go through that 3-part investigative journalist, excellent work, explains a lot of problems with the treatment of corruption in investment arbitration. Ji.
student of Kajaz University. My name is Amza Sarpranja. Sir, correct me if I'm wrong, but when there is corruption in our domestic law and or in any other country, it is seen by the bars, and if it is proved, then their licenses are in danger, so to speak. So what happens in international arbitration if there is corruption? I mean, is it a trust that or is there an institution that sees to it? Please clear this.
No, so for example, let's talk about an ICSID investment dispute. So the claimant filed a request for arbitration. The panel is appointed. We have 3 arbitrators, and there are submissions being made on the merits or on the jurisdiction of a particular matter. And then the state uncovers some corruption in the execution of that investment. So from a corruption point of view, from an international law point of view, it's very important at what stage is corruption discovered. So there's a very famous case, one of the first big corruption cases, ICSID case, it's called Metal Clad, in which, I forget now, was it Kenya or some, but I mean there were literally briefcases of cash being exchanged at the highest levels of government. And so that tribunal basically declined jurisdiction on the basis of, that the investment was procured through corruption. So if it's early on, if a foreign investment is procured through corruption, then you have a better chance of prevailing in that case. If in one of the arbitrations, this arbitrator asked this question that, look, I set up a shoe factory, and 6 years later, I discover that shoe factory is being used to, sell drugs. So what's the consequence then when it comes to one's investment? And again, there have been many awards on the treatment of corruption. And so what happens is when these allegations come to the fore, there's a whole new phase that's created within the arbitration. So the arbitrators will say that, look, okay, our proceedings on jurisdiction or merits will continue, but alongside those proceedings, we will have, you submit a corruption allegation, you submit the evidence, the other side will then reply, and then there will be a separate fact-finding, separate whole process dealing with those allegations. And it happened in Karke, it happened in TCC. When Pakistan unearthed corruption, it presented it to the tribunal. Both tribunals rejected, those allegations. Even though, if you look at the TCC award, there were a whole series of allegations made by Pakistan. Some did prove to be true, as far as this one particular visit of GOB delegation to Chile in 2007 is concerned. So that's something that the tribunal sort of lightly reprimanded the claimant. But yes, corruption is a whole new, it's a very contentious, sensitive issue in these arbitrations. ठीक है जी. Okay. जी बताएं.
सर सवाल मेरा ये है कि
सर क्या कोई टाइम बाउंड नहीं होना चाहिए एक सेट के लिए केस डिसाइड करने के लिए? जैसे हमारे पास जो केस हमने लास्ट डिस्कस किया वो 2011 में आया, डिसाइड 2019 में हुआ. 11 में गवर्नमेंट और थी, 19 में गवर्नमेंट और थी, या यहाँ पे कोई टाइम बाद हम जब बीआईटी करते हैं कि उस बीआईटी को 10 साल बाद रिन्यू किया जाए? चूंकि सर जब एक गवर्नमेंट होती है उनकी पॉलिसीज या रूल्स कुछ और होते हैं या वो किसी और कंसिडरेशन से साइन करती है. जब दूसरी गवर्नमेंट आती है तो उन पे वो पहली गवर्नमेंट का एक बर्डन होता है। और ये जो 2019 में जो सुप्रीम कोर्ट ने जो भी डिसीजन दिए, ये जो गवर्नमेंट ने सीरियस लिया मैटर, जिस तरीके से उन्होंने इसको रिजॉल्व किया, वो इसलिए जबकि इसलिए कि वो हमारे एसेट्स को सीज किया जाने लगा, तो तब हमने उनको सीरियस लिया। तो क्या यहाँ पे कोई टाइम बाउंड एक्सेप्ट की तरफ से भी और बीआईटीज साइन करते वक्त भी क्या नहीं होना चाहिए?
जी देखे हैं, बिल्कुल है। जो डिस्प्यूट्स प्रोसीड करते हैं अंडर द एक्सेड आर्बिट्रेशन रूल्स, उसमें बड़ी एक स्पेसिफाई की हुई है विद प्रिसिशन टाइमलाइंस कि आपने कब अपना पूरा मेमोरियल देना है, आपने दूसरी साइड ने कब उसका काउंटर मेमोरियल देना है, किस पार्टी ने कितनी देर में रिजॉइंडर देना है। सो व्हेन एन आर्बिट्रेशन कमेंसेस, उसकी जो सबसे इंपॉर्टेंट जो डॉक्यूमेंट होता है ना प्रोसीजरली, उसको कहते हैं प्रोसीजरल ऑर्डर नंबर 1। सो वो ट्राइब्यूनल तय करता है विद बोथ पार्टीज। दैट्स द फर्स्ट प्रोसीजरल मेन स्टेप दैट द पार्टीज टेक व्हेन एन आर्बिट्रेशन कमेंसेस. So PO1 governs all throughout the life of that arbitration. The reason why many cases take 10 years, 12 years और 12 साल वाले भी cases हैं the exit system, वो उसकी वजूहात फ़र्क है और वो भी procedural है। वो ये है कि for example hearing हो गई on jurisdiction liability, उन्होंने शुरू में bifurcate कर दिया dispute कि जी हम jurisdiction अभी सुनेंगे, liability अभी सुनेंगे। अगर एक क्लेमेंट सक्सेसफुल होता है इन प्रूविंग के jurisdiction है ट्राइब्यूनल की, liability है रिस्पोंडेंट की, फिर वो एक क्वांटम में जाता है टू डिटरमिन के डैमेजेस या क्वांटम क्या है ऑफ द डैमेजेस। सो दीज आर डिस्टिंक्ट फेजेस। उसके बीच में अगर कोई आर्बिट्रेटर को चैलेंज कर दे, ठीक है कि जी कोई कॉन्फ्लिक्ट ऑफ इंटरेस्ट निकल आया है। पाकिस्तान में टीसीसी में पहले एक आर्बिट्रेटर को चैलेंज किया, प्रोसीडिंग सस्पेंड हो गई, फिर हमने पूरे ट्राइब्यूनल को चैलेंज किया, फिर प्रोसीडिंग सस्पेंड हो गई, 6-7 महीने उधर गुजर गए। सो प्रोसीजरली जितने आप कोशिश करें, ये जब नए नए फेजेस निकलते जाते हैं तो फिर इतना टाइम लगता है। अवार्ड देने में जो नए रूल्स आए हैं एक्सिट के 2022 के, ये आपने बिल्कुल सही सोचा है कि ये एक बहुत बड़ी क्रिटिसिज्म है सिस्टम की कि भाई टाइम क्यों उतना लगता है। तो 2018 मई में आखिरी क्वांटम की हियरिंग हुई, जून में या जुलाई में पोस्ट हियरिंग ब्रीफ सबमिट हुए 2018 के, और फैसला आया जुलाई 2019 में। तो उस ट्राइब्यूनल को 1 साल लगा टू रेंडर द डिसीजन। what the new rules have done एक्सेड इज कि उन्होंने एक आर्बिट्रेटर्स को कहा है कि आप हमें अपना 2 साल का कैलेंडर दें जिसमें आपके पास टाइम है टू एडजुडिकेट दिस डिस्प्यूट। आर्बिट्रेटर्स को आप पाबंदी भी लगा रहे हैं कि वो एक अपनी प्रैक्टिस नहीं कर सकते एज लॉयर्स, और उन्होंने ये अब एक और टाइम लिमिट्स कम कर दी हैं कि आपने ये डिसीजन इस तरह रेंडर करनी है। ट्रांसपेरेंसी की बहुत प्रोविजंस आई हैं कि आपने जितने प्रोसीजरल ऑर्डर्स पास किए हैं वो एक्सेड की वेबसाइट पर पब्लिश होंगे। तो ये सारे इकदाम लिए गए हैं एज वन हैज एक्सपीरियंस्ड these extraordinary delays and problems in the system. Are they enough? That's open to debate. ठीक है जी।
Thank you, Mr. Izad Rahim, for an extremely learningful lecture. Now we will have a lunch break, after which we will have a panel talk on careers in international law. We will be back on 2 p.m. Thank you.
बंद कर दो इसको।
से मैं इंट्रोड्यूस करके Good afternoon, everyone. This has brought us to the close of our lectures for today, and I hope you found them useful and are walking away with a better understanding of the international arbitration landscape globally and in Pakistan. We now begin with our Careers in International Law lecture. Our panel consists of individuals specializing in different facets of international law and come from a diverse background of academia and practitioners. With that, I introduce our panel, most of whom you've heard in the previous 2 days. Mr. Rana Sajad Ahmed is the founding president of SICA. He is a dual qualified lawyer having over 15 years of experience practicing law and arbitration in Pakistan and the US. Dr. Nudrat Piracha is leading the legal team of Pakistan's first global law firm, Samdani and Qureshi. She has served both as counsel and arbitrator in international investment arbitrations. She was also nominated to the panel of arbitrators by ICSID by Pakistan. Mr. Ali Zahid Rahim is a partner at Access Law Chambers. He is an international arbitration expert with particular experience in investor-state dispute settlement. He has also served at the World Bank's legal department at its headquarters in Washington, D.C. And finally, Mr. Jamal Aziz is an international law expert in Pakistan and currently serves as the Executive Director of the Research Society for International Law. He also serves as the Director of the Center for Excellence for International Law at the National Defense University and is a member of the Prime Minister's Working Group of Experts on Pakistan's international investment regime reforms. With that, we begin the session. So every speaker will have 5 to 6 minutes to share their insights on possible opportunities and careers in international law, and then we'll open the floor for a conversation and questions. Thank you. We can begin with Mr. Rana Sajad, and you can keep on sitting.
Thank you. I think with the one woman on the panel would have been appropriate if Nidra started out, but yes.
You're too kind.
Okay. So thank you for this opportunity. We're talking about careers in international law. I'll focus on international arbitration. I think I'll start off by saying that, as far as international arbitration is concerned, the center of gravity is shifting eastward. Ali referred to this in his presentation as well, which I think for Pakistanis is a good sign, because end of the day, let's face it, in this day and age, being a Pakistani, being a Muslim, doesn't sit too well sometimes with certain countries around the world, and the color of your skin does matter. So I'm being very upfront here. But the fact that the center of gravity is shifting eastward is a good sign, because all the transactions, all the disputes are moving eastward. So being a Pakistani, being a South Asian, stands you in good stead in terms of opportunities. Now, how to go about this? If you talk about international arbitration, the standard route to becoming an international arbitration expert is, of course, applying to a large law firm, working in the international arbitration department, making partner. But that's, it's quite tough. It's quite challenging, especially for somebody, coming from Pakistan. And of course, most of you are based in Pakistan. I mean, my advice to you would be to focus on arbitral institutions. So there are a lot of arbitral institutions and international institutions which offer internships. Unfortunately, I think most of them are unpaid internships. So it's a bit of a labor of love. But then, of course, if you really love it that much, might as well pursue it. So what that would do is, so let's say, Ali talked about HKIAC, SEAC, those are two leading centers for international arbitration in Asia. Perhaps if you could land an internship there as a case manager, you start out as an intern and then build on that. What you will get in the process is you'll get experience under your belt regarding how things work inside an international arbitration center. How the case starts, how you manage the case, you learn about the procedural aspects. And I know of people, not Pakistani people, I know of at least one Indian person and one person who's based in Paris, who actually did this as well. They worked with a reputable international arbitration institution. They spent, let's say, 5 to 10 years with that institution, and then they branched out. They left that center, either set up their own practice, set up their own chambers to serve as arbitrators, or joined a large law firm as a partner. I'm not saying your story would be exactly the same, but my point is, it's probably easier for you to go down this road as opposed to thinking that I have to work with an international law firm to build my career in international arbitration. So perhaps it makes sense to do that. And then, of course, something that I think Sadia has done, I was reading her profile yesterday, she's gotten certifications, trainings from the Peace Palace, The Hague, some other centers as well. I think some of them you can do online as well. And I think we were chatting about this a bit earlier as well, that, it all comes down to self-learning. You can't just expect to find mentors. It's difficult to find mentors even when you're, sitting amongst them. So you have to basically be driven to figure out, how, without even, let's say, a degree from an Ivy League law school, how you can build your profile with those certifications, trainings, and hopefully with an internship. And then, of course, the key for lawyers is writing, publications. And I think I was chatting with somebody yesterday as well. I said that, you don't have to rely on publications in international journals. That would be great if you can do that. But, in this day and age, it's about blogging as well. And I don't mean, blogging about things that are not relevant. You could carve out a niche for yourself by blogging, by writing blog posts on rising issues, evolving issues, that are unique to Pakistan, South Asia, or this region, and perhaps, global issues. And that is how you get noticed, because, the blessing or the privilege of having the internet is that, if you really have something, if you have that craft, and you can showcase that through your writing, go right ahead. So in a lot of ways, I think the way I'm pitching this to you is, it sounds very easy. But of course, it requires a lot of dedication and effort as well. But I think if I were to, go back, let's say 20 years, and if somebody was advising me about my career, I think this is what I would advise them, that, this is probably an easier career path, which can reap dividends. Thank you.
Thank you, sir. Dr. Paracha, please.
I should have taken his offer. He has left nothing for anyone else to say. But some of the tips that I can add on to what he said, I completely endorse. Yes, institutions. PCA offers internships for students. ICSID offers internship for students. So if you're studying somewhere, definitely check out these institutions. They have 3-month internships. That's a good place to start. Law firms who have experience in arbitrations, that's a good place to start. In addition to that, there are young member groups. Most of the centers have a young member group. Do try out the International Transnational Arbitration. That's a forum, that's an organization. They have a very strong young members group. So these are relatively inexpensive. The young member groups, do try them out. I think what I can share from my experience is, I was starting 20 years back, and arbitration was not that known in Pakistan at that time, especially in the law firms. And I think I ended there just by chance. The senior partner, he did not want me to work in litigation, and I asked him that if I don't work in litigation, what else do I do? And at that time, SCS was a client. We were starting off with the Binder case in ICSID, and I just ended up in the right place at the right time. So luck definitely, I think, played a big role in where I got. But what I did was, with very little opportunities in Pakistan, I was very keenly aware that I constantly need to grow. And there were not many opportunities in Pakistan to do that. So what I did was, I kept taking these courses from Chartered Institute of Arbitrators, and there were very few people trying out anything new. And I think when I qualified, when I did my CRB certification, I was the first lawyer from Pakistan to become a fellow of CRB. And many of the things that I have done in life, I invariably find out that I'm the first to do it. I did my SJD, which is a doctorate in juridical sciences, highest degree of law in US in investment arbitrations, and then I found out I was the first woman from Pakistan to have done a SJD. So being curious, and this, I think this, I would call it obsession to grow. That is very important. Opportunities, they are difficult to come by, but it is extremely important that you are ready for the opportunity when it turns up. So you constantly need to prepare yourself. You cannot guarantee the opportunity is going to come your way, but you need to be prepared. That's something you can guarantee. Working with professors is a good idea. Many of the professors need researchers, they need help with their cases. Do reach out to professors. And one of the mistakes I commonly find with students from Pakistan is they would write either the name wrong, and people in the West, they are quite offended. The first thing anyone is going to notice is their name. Then the students from Pakistan generally skip their titles. So someone has spent 5 years becoming a doctor. If you just skip the doctor, they are quite offended. So you need to pay special attention. You send those emails, pay special attention to their names and titles. So in US and UK, when I joined, the concept was that this is a field for what they called the male, pale and stale. Right, so the pale meant it has to be a white person, stale meant you have to be very old, and male is obvious. It's been a long journey. Even in the West, it is still very difficult for women to break in, even more difficult in Pakistan to break in. But I think it's tireless effort. It's a difficult field, especially for women. They need to think 10 times before they decide joining this field. It's constant work, and because you're dealing with multiple jurisdictions, in any investment arbitration, you have about 7 to 8 nationalities in the room, which means that you're dealing with at least 7-8 different time zones. Someone might give you a call, the expert is calling at 8 a.m., but it might be 2 a.m. for you. So the, I think, biggest challenge in arbitrations is the time zones. So you need to be very sure that you want to enter this field. It requires, as I say, constant, dedicated work. In addition to that, I think Rana Sajjad covered all the basic tips. So my last advice to you would be just that. Keep working, keep preparing yourselves. There are courses now out there in Pakistan. CR would be one. Rana Sajjad, the SICA is offering courses. I have created a center by the name of International Center for Appropriate Dispute Resolution and Prevention. We have created collaborations with American University, George Washington University, and Pepperdine University to bring the best ADR courses to Pakistan. Do keep a lookout for that as well. We are trying to run the summer courses this year. So do keep a check on ICAD website as well. So thank you.
That was really excellent and impressive, and I think I'll speak about my own journey as a lawyer. And so basically I started off with a local Lahore-based law firm in 2002 and worked there for 5 years. There wasn't much international work other than contracts for the few sort of foreign parties. So when I went for my LLM in 2007, I took this course at Berkeley, which was being taught by a very famous international law person who passed away, Dr. David Caron. And this course was about resolution of private international disputes. So this was private international law, international litigation. And, I didn't think much of it. I really enjoyed the course. I struck a chord with Dr. David Caron. Till he passed away, sort of remained in touch with him. That goes to the point of that when you do go for your further studies, it's important to forge relationships with your professors. And, they keep regular office hours. They're keen to talk to students. So you should not be shy, and, you should make the most of this great opportunity if and when you do get it. So then that semester for United States LLM students, for international students, they had a career fair in New York at NYU. And I remember, this is 2007 December, I applied to 30-40 places. With very low expectations, because I was told point blank by the careers office at that point in time that no one's really interested in law students from Pakistan. Law firms in America at that point in time preferred students who could speak Spanish, who could speak French. And I think that's very important for you to understand the value of learning another language. So, and in the whole UN system, when it comes to international law, if you know another language, then that's a real plus. So that immediately sort of sets you apart. And many jobs that are advertised specifically, say that we want a native Spanish speaker or a French speaker. Unfortunately, Urdu, Hindi for people from South Asia, no one says that they want someone who can speak Hindi or Urdu or Arabic, yes, to a certain extent. But anyway, going back to that job fair, I was interviewed by the World Bank in the first round, and they called me back in February the next year to the headquarters, interviewed by a panel of five sort of different panels. And at that point in time, the World Bank had a very famous young professionals program. So that was the sort of main conduit for people from developing countries who joined the bank. This was started in the 1960s, 70s. So the legal department had their own young professionals program called Legal Associates Program. So I became a member of the class of 2008. Since my time, that program has now been disbanded. So recruitment now doesn't sort of take place through that particular pipeline. It's more ad hoc, but positions are advertised. And so from 2008 till 2010, I spent 2 years at the legal department, but realized that it sort of wasn't for me and my personality, because when you join an international organization, the work is quite bureaucratic, and it was just a personal preference at that point in time. So I returned to Pakistan, Lahore, in 2010, and set my own law firm up. And during the first 2 years of my practice, I worked on a domestic arbitration. We had a sole arbitrator, an excellent retired High Court judge of the Lahore High Court. And really that was my sort of first foray into working on an arbitration matter. And then later I got other opportunities, worked on international arbitration matters. So as Ms. Pracha and Mr. Sajjad said, there's no sort of magic formula. It's just very important that in law school you perform well. Then after law school you work hard, because if you set out thinking that you will get an international law opportunity in Pakistan, I think again the market isn't sort of big enough for one to say that. It's not specialized enough for one to take that call. There are no sort of specialist law firms that only deal with international disputes. So my advice would be to become a sound, excellent lawyer all around, and then, you know, when you get an opportunity to work on an international law matter, you'll realize that many things are instinctive. Many things, you know, dealing with procedure, it's not rocket science. It's just, you know, making sure that you read the text and you are diligent about, you know, going about what's being assigned to you. So I think lastly, it's very important for you to get a break, and for you, I mean, there's a lot of competition, right? So as Mr. Sajad mentioned, it's very important for you to publish, because when we, you know, come to international law, there's a lot of text, there's a lot of treaties, there are different sources of law, and if you do develop an interest, obviously you have to read a lot. But if you can improve your writing ability, if you can publish, then immediately that sets you apart from the competition. The fact that you have a CV in which you've stated that you've published ABC. So often, you know, law firms, international organizations, when they look at someone's CV, they also require writing samples. And, you know, that's your sort of opportunity, your moment to demonstrate your writing ability. So I think people often underestimate one's writing ability. It's very important in our profession, as you know. And I think I would just emphasize working on your CV and knowing how to frame a CV. We get CVs from all over Pakistan, and you would be surprised at how, you know, basic some of the mistakes are. Again, a lot of typos, etc. So that, from a career point of view, you need to know what a good CV looks like. You need to know how to draft a cover letter. And as I said, you need to have excellent writing samples ready, so that, you know, someone who has to evaluate you can look at the complete picture. And then obviously it's the interview, it's luck, all of those things obviously play a vital role, but that's all I have to say.
Bismillahirrahmanirrahim. Yes, sir. Absolutely, sir. That is the challenge. Sir, all the topics have already been discussed. Miraji, I would like to give a more of a background into public international law and the opportunities that exist in Pakistan. मेरा तो ये था कि I was fortunate that I began my career initially. मैंने corporate law में I was working at Odignum, but it, you know, didn't really, you know, suit me. तो उस टाइम पे यही जो आपका अर्ली 20s का टाइम होता है, उसमें कंफ्यूजन होती है, there's a lot of pressure as well, and the natural inclination is कि CSS की तरफ जाएं. You know, CSS, so I was also part of that, you know, I fell into that trap as well, but turns out कि because मैंने अपनी एजुकेशन कुछ अरसा जर्मनी में की थी, तो उन्होंने कहा कि आपने उर्दू पाक स्टडीज़ इस्लामियात नहीं पढ़ा, तो एज अ रिजल्ट, you know, you have to do that first. So during that time when I was, you know, feeling quite despondent and down about my options, I was fortunate to meet Mr. Ahmed Bilal Sufi, who has been, you know, the leading proponent of international law, the father of international law in Pakistan, I would say. And उन्होंने मुझे inspire किया कि, you know, this is a whole new field and a different paradigm, and if you want to help your country, because CSS बंदा क्यों करता है? You know, you have this, you know, your early 20s में you're very passionate and you want to do something for your country and you want to contribute, and, you know, you think the best way is to become an assistant commissioner or, you know, join the foreign office. Sufi साहब ने मुझे बोला कि you can do all that and more much faster if you pursue the field of international law. Now he had spent the previous 20 years before that trying to make the case कि international law भी एक चीज़ है. And when he started, it was, you know, people were laughing at the fact, yeah, ye kya, you know, what are you talking about? Why should you go into research? Now, I entered at a time when it was the second generation where people had understood the importance of international law, but having a career which pays, because कहाँ से पैसे आएंगे? Like जिस तरह सर ने बोला कि आपका market ही नहीं है. You don't have
enough of a sophisticated legal system in place कि आपके पास international cases आ रहे हों, ना आपका ecosystem है यहाँ पे. So how do you make that happen? So me and some colleagues along with me at RSIL, we spent the last 10 years trying to make that viable. कि international law not only can it be a field where you work in, but it can also be something where you can thrive in professionally, and that pays the bills quite well. So वो एक field आ गया. Now during this time, we have gone into the third phase of evolution, where across the board state institutions have begun to understand the importance of international law, because Pakistan को पिछले 6-7 सालों में इतने high profile setbacks हुए हैं, whether it was on the investment side, arbitration side, or whether it was lawfare maneuvers like the Yadev case, or the different Kashmir related matters have happened. FATF की आपकी grey listing हुई है, which was all very technical, anti money laundering, terrorism financing reporting, फिर आपकी nuclear reporting होती है. So human rights, so many issues have come up. Indus Water Treaty का भी वो है. So across the board, we are now at an evolution in Pakistan where state institutions, at least half a dozen ministries, and all your armed forces, all your intelligence agencies, all your public sector agencies, they have begun to understand the importance of international law, and setups are being created. मसला यह है कि अभी लोग नहीं है. IPRI में भी lawfare chair बनने में it took so long to find Maham. She's doing a fantastic job. National Security Division में space नहीं है. NDU में हमारा center बन गया है, लोग नहीं है. Right? So there is now a lot of career opportunities which were not there even 10 years ago. And if you just look at Pakistan and its neighbors, whether you look Pakistan, India, territorial disputes हैं, water sharing के आपके matters हैं, trade related आपके issues हैं, China के साथ आपके G2G contracts है, CPEC है, alternative dispute resolution के the Chinese want कि आप उस पे ज़्यादा focus करें. ईरान के साथ sanctions का matters हैं, pipelines की issues हैं, security matters हैं. अफगानिस्तान के साथ you need to also have transit trade, refugees matters. Alongside all of this, you have counter-terrorism operations taking place in the country. उसके legal frameworks, the world has changed. And in this multipolar environment, whether it is human rights, whether it is nuclear, whether it is climate change, whether it is global governance institutions, इसमें US-China की जो rivalry है, उसमें we are seeing battlegrounds happening across the world. पहले जब सूफी साहब lawfare की बात करते थे तो लोग कहते हैं कि ये कोई फौजी लाइन बात कर रहे हैं, this is all propaganda. But now Yale University and Harvard and Columbia and all of these are issuing detailed papers on how the Chinese and the Russians are using lawfare. The US is setting up national command on lawfare, right? So why? Because artificial intelligence, development finance, climate change, high seas, cyber security, यहाँ पे norms and standard development पे battlegrounds बन रही हैं. Who should have the upper hand? The Chinese are developing doctrines. अच्छा फिर multipolarity हो रही है, multilateralism से आप हट रहे हैं, and you are seeing new institutions like BRICS and SCO and AUKUS and RCEP, इनकी mechanisms बन रहे हैं. So these are all the spaces where now Pakistan needs to have very high level of capacity. And हमारा objective at RSIL is to develop that capacity. We need, I understand कि we are one generation behind. Some would say we are 3 generations behind, but I would say कि हमें 20 साल की मेहनत करनी है, and you guys are the future. 20 साल का जो upcoming batch है, we have to train. My dream is कि हम by the time I am an old person कि कोई 200 international lawyers हमने पाकिस्तान से train किए हों, highly specialized in different technical fields, and make the advocacy of getting you guys in these international institutions with the help of the networks that we already have. अभी पिछले 5 सालों में RSIL से we've gotten 3 people into Harvard, 2 into Cambridge, 2 into Oxford, 4 Shivning scholars, 2 Fulbright scholars, and our people are now working in UN में in New York, in Vienna, at the IAEA. So मेरी ही batch से 5-6 लोग हमारे सामने ही इंटरनेशनल ऑर्गेनाइजेशंस में आ गए. वी नीड टू हैव दिस एनवायरनमेंट बिकॉज जो हमारे चैलेंजेस हैं पाकिस्तान के, दे आर टू बिग टू बी टेकन ऑन इंडिविजुअली, एंड इट कांट बी कि ये मेरा फील्ड है, मैं इंटरनेशनल लॉ का बंदा हूं, आई एम गोइंग टू स्टॉप यू फ्रॉम एंटरिंग माई फील्ड. आई एम टेलिंग यू माई फील्ड रिक्वायर्स hundreds of people, but it requires you people to show that seriousness because the game is international it is strategic, and we have very poor capacity. So we are trying at RSIL to start developing degree programs. It's very difficult because HEC hai, universities hai, zameen chahiye, flana, wo sare matters hai, but that is for us to figure out, and for our friends in IPRI and others to help out. But when those institutions are made, those degree programs are made, it is for you people, for you to take them seriously. Stop doing these random degrees. International relations में और इन चीज़ों में अभी degrees की पाकिस्तान में ज़रूरत नहीं है. You need to have technical degrees focusing on specifics, and then work on standard setting as well. So that, with that I'll stop and happy to take questions. Thank you.
I agree with what everyone said, और मैं थोड़ा सा आपको उसके अंदर ये echo करूँगी कि international law के अंदर भी there are multiple fields. So you've seen how there are certain people who specialize in international investment law, then there's in public international law, then there's, अगर आप उसको और further चले जाओ, international human rights law, international law of conflict. मेरा personal experience here, I started off with international arbitration and then transitioned into public international law. So the idea being that international law is big enough for you to even work within that and then find your own grounding uske andar. As a career, I'll be very quick. One thing I would add, and is something Pakistani students should look at, because I myself have gone through that and I know a number of Pakistani students who have as well. There are international law firms जो internships offer करती हैं और वो paid होती हैं. Uska criteria being that you should have excelled exceptionally in your undergraduate degree and then had a grad school degree. और जब आप अपने grad school में होते हो, so White and Case, Sherman and Sterling, Eversheds, these are magic circle firms. इन सबके paid internship programs होते हैं. जो work requirement और visa issues US में होते हैं, वो Europe में उस तरह नहीं है. So Spain, Paris, Geneva, these are places where you can look into options के क्या है, because international law Europe के अंदर is a very big thing. Like for instance, Paris में they say international law is a bigger market than their own domestic law. So that would be something you should reach out to partners. देखो कौन सा partner कहाँ पे situated है. Reach out to them directly. Usually they're nice about it and they would reply. वरना वो आपको किसी HR को कर देते हैं refer. One thing you would need to ace in that is your interview. So like work on your English speaking ability, on your communication skills, and generally it's going to sound bad, but you need to be able to sell yourself कि अगर 400 लोग apply कर रहे हैं और उन्होंने 6 लोगों को अपनी internship program में रखना है, paying like 2,500 to 3,000 euros a month, which is a decent amount, लेकिन वो आपको क्यों रखें? So generally what I have seen is, because I used to interview for one of the law firms, Pakistani students usually on paper strong hote the, so they would get selected for the interview process. They would lack the communication skills that enable them to go to the next level. So that is another thing that you should look at, is law firms with offices in Paris, London, Geneva, Spain, because Madrid, all of these places also are big on international arbitration in particular. Public international law mostly is still a smaller field, but the larger international law landscape is big enough for you to find an opportunity. We'll now open the floor to questions. Does anyone have a question?
Assalamu alaikum. My question is from Sir Ali Zahid Rahim. Sir, you mentioned that first you practiced in Pakistan and then you went for the LLM in 2007, I guess. So, sir, this is a question that troubles many students here. That should we keep in touch with the local, domestic, and district courts and their workings and all the ins and outs, and should we engage? Should we, even if we want to pursue international law, even if we want to pursue international arbitration, and should we still keep in touch with them, the domestic scenario?
Yes, absolutely. I think the skills that you learn your first 2 years doing, let's say, civil court litigation, high court litigation, those skills are critical when it comes to procedure and international arbitration procedure. So again, it's those skills are easily transferable, and alongside, you get so busy with domestic work, you have responsibilities working for the law firm, and all of that work, you can make a special effort to keep up with what's happening internationally. And as I said, Pakistan's had a very interesting decade. There are lots of materials out there that you can sort of go through and understand, the regime. Let's suppose, read the decisions, read the awards. So I think doing both is possible, even though 90% of your time will be understandably spent on what's assigned to you. But it'll take some extra effort, but there's no reason why you can't do it.
तो आपने कहा कि इंस्टीट्यूशंस के अंदर हम इंटर्नशिप वगैरह कर सकते हैं, तो हमारा बीइंग वेरी रियलिस्टिक, यूएस के अंदर हम ग्रेड स्कूल के लिए, मिडिल क्लास के लिए इतना ज़्यादा एक्सेस नहीं है, तो HKIC या SIAC वहाँ भी हम वर्चुअली इंटर्न शायद मौका मिल जाए अगर आने वाले सालों के अंदर, जिस तरह ब्राइटन नेटवर्क या जिस तरह बाकी चंद एक इंटर्नशिप ऑफर करी वर्चुअल, तो वो तो हम कर सकते हैं, लेकिन हम फिजिकली उस तरह हमारे पास एक्सेस नहीं है। मैम ने भी प्रोसीजर थोड़ा सा एक्सप्लेन किया कि हम पार्टनर को रीच आउट करें या वो सारा, तो ये इसके अलावा लाइक वर्चुअल तो हम कर सकते हैं। पाकिस्तान के अंदर फर्म्स कौन सी ऐसी मौजूद हैं जहाँ हमें करनी चाहिए, एक्सेस हैं आपकी फर्म करती हैं, इनके अलावा लाइक प्रैक्टिकल ये फिजिकली हमारे पास क्या अपॉर्चुनिटीज मौजूद हैं, फिजिकली का थोड़ा सा बताइए मुझे।
इसमें आपके पास जो है कुछ अपॉर्चुनिटीज हैं, इफ यू कीप अ लुक एट 2 जगह हैं, अपॉर्चुनिटीज कॉर्नर, उस पर जरा नजर रखें। दूसरा एक और है ऑजमिड, उसे कहते हैं OGMID, ठीक है, वहाँ पे यंग जो ग्रुप है दे आर वेरी एक्टिव अबाउट जितनी भी निकलती है ना अपॉर्चुनिटीज, मैनी ऑफ देम आर वर्चुअल, ठीक है। अब पिछले दिनों भी एक्सिड में मसलन जो चल रही थी दैट वाज अ वर्चुअल ऑफरिंग, कोविड के बाद हाउ मैनी ऑफ देम आर गोइंग टू बी वर्चुअल इज टू बी सीन येट, मगर अपॉर्चुनिटीज इफ यू आर अ स्टूडेंट देयर आर अपॉर्चुनिटीज इन US as well, and if you keep an eye at OJMID you will get to know which opportunities those are. Pakistan में core focus on arbitrations, I echo what has been said कि कोई भी firm does not have a niche arbitration practice. There isn't enough work in Pakistan to justify a niche arbitration practice. मगर जैसे कराची में फजले गनी है, ठीक है, मखदूम अली खान साहब का चेम्बर does a lot of arbitration work. इधर जो लोग हैं आज, they have arbitration practices. But Pakistan में it is, you're right, difficult to find a law firm who have substantial arbitration work. कुछ उसमें skill sets, I would again agree, some skill sets are the same for lawyers, but for arbitrations I would say the skill set, lawyering skill set is very different. ठीक है, उसके लिए जो है पाकिस्तान में आप कहीं पे भी काम करेंगे you will not get that skill set जो कि arbitration में चाहिए। बहुत सारे हमारे यहाँ के lawyers they run international arbitrations as if it was a local arbitration, does not go down very well with international tribunals, ठीक है। So वो skill sets आपको पाकिस्तान में मुश्किल मिलेंगे unless people have actually worked in international arbitrations. There are only 3 to 4 firms that I know of who have good international arbitration work, so the market is quite small पाकिस्तान में। यूरोप जो है आई हैवंट ट्राइड फॉर यूरोप, बट आई डू नो कि इन US अगर इस पे ऑजमिट पे आप कीप अ चेक, देयर आर अपॉर्चुनिटीज जो आप वर्चुअल भी यू कैन टेक देम ऑन।
Anybody
anybody who can answer to my question. But मैम आपसे start करूंगी कि आपने skill set की बात की कि हमारे पास skill set में मौजूद नहीं है पाकिस्तान में. Exactly कौन सी skills हैं जिन पर हमें काम करना चाहिए for us to understand कि international law में हमें जगह बनानी है, क्योंकि लोकल कोर्ट्स की प्रैक्टिस में और इंटरनेशनल कोर्ट्स की प्रैक्टिस में ज़मीन आसमान का फ़र्क है. और जहाँ हमारे लोकल जो हमारे लॉयर्स हैं यहाँ बहुत बड़े बड़े नाम होंगे लेकिन वो यहाँ बड़े नाम हैं, हम अगर उनके साथ काम कर रहे हैं तो हमें वो स्किल सेट नहीं मिलेगा. हमें शायद बहुत सारी डिफरेंट चीज़ें सीखनी पड़ेगी. यहाँ हेरा फेरी भी चल जाती है यहाँ, तो वहाँ नहीं चलती है. तो वहाँ के लिए भी हमें कौन सी स्किल सेट्स को बिल्ड करना है. जो दूसरा क्वेश्चन है सर, आप में से जो भी आंसर कर सके कि पर्टिकुलरली मैं ADR में इंटरेस्टेड हूँ और उसी का ही एक कंपोनेंट हमारे पास आर्बिट्रेशन था. दैट्स व्हाई आई हैड टू कम हियर. डोमेस्टिकली और इंटरनेशनली ADR में कौन सी ऐसी चीज़ है जिसको परस्यू करना चाहिए, कौन सी ऐसी चीज़ है जिसको हमें सीखना चाहिए. हमें पता है मीडिएशन भी है, बहुत सारी और भी चीज़ें इसके अंदर आती हैं. कौन सी ऐसी चीज़ है जो वाकई वर्थ इट है कि हम उस पर टाइम सर्व करें अपने, क्योंकि बहुत सारी जैसे कि हम मीडिएशन के बारे में पढ़ते हैं तो वो इस तरह की चीज़ है कि वो ऐसा लगता है जैसे जगह का फैसला हो, तो वो भी एक तरह की मीडिएशन ही है. तो क्या हमें वाकई इंटरनेशनल लॉ में मीडिएशन पे टाइम लगाना चाहिए या नहीं. ऑल्सो हमारे पास जो कंट्री के अंदर डोमेस्टिकली अगर हम ADR करते हैं, जिसको हम आम जुबान में सालिसी कहते हैं कि जी आउट ऑफ कोर्ट सेटलमेंट हम करवा लें दो पार्टीज की, तो डू यू थिंक इफ वी डोंट परस्यू फॉर इंटरनेशनल लॉ तो क्या हमें डोमेस्टिकली इस चीज़ को देखना चाहिए कि नहीं, क्या हमारे पास इस तरह की कोई चीज़ है कि नहीं. थैंक यू.
थैंक यू जी, वेरी गुड क्वेश्चंस. पहला आपका स्किल सेट वाला जो इशू है, स्किल सेट जो लॉयरिंग स्किल सेट है दैट इज एडवोकेसी स्किल्स फॉर आर्बिट्रेशन लॉयर्स. ये आपको बहुत सारे सेंटर्स इस वक्त हैं उनके कोर्सेज मिल जाएंगे. SCC ऑफर कर रहा है, हांगकॉन्ग सेंटर ऑफर करता है, ICC ऑफर करता है. फॉर यंग प्रैक्टिशनर्स there is a huge list of courses that are being offered by the centers. उन पे एक नज़र रखिए. एडवोकेसी स्किल्स आर इम्पोर्टेंट. अब तो यू कैन इवन फाइंड skill sets for people who want to serve as secretary to the tribunal. Those are skill sets you can acquire. Drafting skill sets hain. How do you go about that? Arbitration drafting is very different from the drafting that we see in Pakistan. इसके अलावा I would encourage you the law moots that are happening. Abhi bhi I'm organizing a law moot which is an investment arbitration law moot. June 1st I think is the deadline for the universities to register for that. Uske national rounds hain, people who make it to the international rounds, that is in the US then. Law moots are a very good way of learning how things actually happen on an international level. So you need to try to see which skills you need in particular. Law moot would give you an exposure to the real thing. और फिर वो आपकी एक सेल्फ असेसमेंट है कि व्हाट इज द स्किल. जैसे व्हेन यू विल स्टार्ट यू विल सी कि ओके क्रॉस एग्जामिनेशन इज समथिंग आई एम नॉट गुड एट. ठीक है, सो दैट इज अ पर्सनल चॉइस. व्हेन यू गो थ्रू द प्रोसेस अपनी कमियां आपको खुद भी समझ आएंगी. बट टू बिगिन विद आई थिंक लॉयरिंग स्किल्स फॉर ADR that is a key skill set that every student needs to have. दूसरी आपने बात की अपॉर्चुनिटीज़ की. मीडिएशंस हैं, आर्बिट्रेशंस हैं, whether it is worthwhile to invest time in mediations for instance. पाकिस्तान में मीडिएशन की ग्रोथ आर्बिट्रेशन से पहले होगी. ठीक है, बिकॉज स्पेशली इन द फेडरल द लॉ इज प्रोवाइडिंग द रिक्विजिट सपोर्ट. इस वक्त जो है all the things that need to be aligned to encourage mediations in Pakistan are aligned. हम unfortunate रहे in the past क्योंकि जो भी efforts हुई they were one person effort. जैसे ही बंदा गया systems back पे नहीं थे तो those efforts collapsed. इस वक्त there is a systematic effort towards mediations क्योंकि recognition is very clear कि you have 2 million cases pending in the courts. अगले 70 साल में भी ये cases कचहरी में resolve नहीं होने लगे. So the judges are very keen to have proper mediation programs, sustainable mediation programs. If you are interested in mediations, Pakistan it is a very good time to make it into the mediation area. Arbitration still क्योंकि legislative support अभी नहीं है. 1940 का एक्ट अभी मौजूद है. जब तक उसके बारे में कोई फैसला नहीं हो जाता तब तक arbitration की उस तरह से systematic support नहीं मौजूद. and 1940 arbitrations are just like any court कचहरी का जो आपका केस है. So law में जब तक हमें support नहीं मिलती arbitrations की growth और उसमें change आहिस्ता आ रही है, but it will definitely happen. In the meanwhile, having these skill sets, mediation का skill set बिल्कुल different है, but आने वाला जो time है, what I am seeing internationally, जो clauses आ रही हैं, there is emergence of med-arb clauses, which means कि it's a merger of mediations and arbitrations. The first option जैसे usual clauses होती थी कि आपने settlement करने की कोशिश करनी है पहले, settlement नहीं हुई, then you go for the whatever the dispute resolution choices, ICC है, exit है, whatever. अब you are seeing with the signing of the Singapore Convention, जो अभी पाकिस्तान ने sign नहीं की, it would be a good idea to sign that on पाकिस्तान के लिए. मगर जो आगे आने वाला internationally इस वक्त जो shift है, that is towards med-arb clauses. So ज़्यादा fit in वो लोग होंगे जिनके पास दोनों skills मौजूद होंगी. They know arbitrations and they know mediations. वरना आप जो clause होगी उसमें जो tiers होंगे, one of them is going to be mediations. अब significant institutions, even ICSID in 2022 has introduced mediation rules. This was never the case before. Singapore Convention की signing जिस तेजी के साथ हुई है, that should tell you about the popularity of mediations. Sophisticated world is moving towards mediations और वजह भी है उसकी कि आपके arbitrations में जैसे ICSID का कल मैं कह रही थी कि जो arbitrator की तनख्वाह है वो सबसे सस्ती है ICSID में, and that is about $3,000 a day. 8 घंटे के दिन का $3,000 वो हमें देते हैं only. And ये सबसे सस्ता ऑप्शन है if you in investment arbitrations. So the scales of the fees that you have to pay in arbitrations, और फिर आपके 2-3 साल तो कहीं नहीं गए. Mediation में most complicated जो disputes हैं, they have been resolved in 3 days. ठीक है, commercial disputes. जो बाकी disputes हैं जिसमें बहुत पुराने controversial चीज़ें चलती आ रही हैं, they might take a week, 2 weeks, but not more than that. So there is a clear recognition in the developed world at least कि mediation is the way to go. आपके पास future में 10 years from now, if you do not have mediation skills, आप market में से out हो जाएंगे क्योंकि लोग usually would want to go to those people who have both skill sets. So I don't think you should be choosing at this point. पाकिस्तान की market में make the best of it क्योंकि mediations are gaining popularity very quickly. Do make the best of that. और arbitration skills of course साथ के साथ take those CRB courses, SICA courses, ICADEP courses, whatever takes your fancy, but do take those courses for arbitrations as well.
And I think speaking of courses, there's this one institution, I think Mudrat might be able to correct me, it's called FICA, it's based out of Switzerland. They have a fascinating, I believe, 2-3 day program. I took that as well at some point, and I thought that was the best training program. I've taken one with another one as well, but I thought that was a fascinating practical advocacy training program. So, and it's not very expensive. You might want to look that up. And I think in terms of career growth, end of the day, I mean, the question arises that, you know, even with all these trainings, all the certifications, you really get busy as an arbitration lawyer. I mean, there is no guarantee, right? But my advice to you would be, because I mean, the sense I get from a lot of people is, you know, they don't have the wherewithal or the resources to actually travel abroad, you know, pursue full-fledged degree. I understand, huge undertaking. I personally would say, you know, certifications trainings is the way to go. And if you can find trainings online, which is very cost efficient, do that as well. And I think another thing I would encourage you to do it, another pointed to that was being part of these young groups. So Young ICA is another big one as well. So ICA is considered like the mother of art institutions because they have this biennial conference once every 2 years because it's a very special, prestigious event. They have a young group as well. And I think one thing I would encourage you to do is that, you know, get involved with them in an official capacity. So let's say they have these rotating positions for these young groups. You know, they have regional positions. And I was much older when I started looking at these, but I wish I knew about this earlier. But you don't see a lot of Pakistanis even applying for these positions. You see a lot of course, Indians, people from Dubai in this region. You don't have to pay anything for that as long as you meet the eligibility criteria. Apply for those positions because that will give you visibility as well. Because what will happen is you will be the default organizer of some event You probably have to travel to some location as well, let's say Dubai, Oman, Qatar, for some event also. Because, yeah, eventually there is no substitute for in-person networking and meeting people. And okay, so you have to be very smart with your budgeting as well. So perhaps pick a conference, a location where you decide to go maybe once a year, once every 2 years. But you have to be consistent with that. But if you associate officially with an organization, what that will do is you'll automatically be, connected with everything that is going on. You'll learn a lot, you'll network, people will get to know you better, and that can help you a great deal as well.
One part of the question was, in case I want to pursue my LLM degree in international law, but not exactly international law, or the things we discussed about, what are the ways, what are ADR makes it cost options, and what are the options we do have internationally, and do you have any recommendations in terms of any college, any institution, any university, any country we could present for anything under ADR, because that's a vast field.
So I can speak for the US as far as I know. I think except for GW, they don't have specialized LLM programs, and LLM is a general degree, right? So you can have whatever coursework you like. But in Europe, Maham talked about Europe, I believe Belgium and Germany, they have some universities that offer specialized LLMs in international dispute resolution, international arbitration. And I think, from what I know, European law schools are the cheapest. So Americans are the most expensive, American law schools, followed by the British law school. And I think the Europeans, they're not that expensive. So you might want to look at those as well. 1-year programs, I believe, and they're specialized international dispute resolution and arbitration programs.
Okay. In America, sorry, I would just want to add, in America, Pepperdine University is one of the oldest. Pepperdine University. It's been offering ADR courses for the last 40 years. So I think maximum variety आपको मिलेगी if you look at their offerings. उसमें short courses भी हैं, long courses भी हैं, but Pepperdine University is one. American College again has Washington College of Law, WCL. That again has a very wide variety of offerings for ADR courses. So if you were looking for a wide range, do take a look at WCL and Pepperdine University.
Sir, Assalamu alaikum. Sir, my question is from you, Sir Rana Sajjad. Sir, I read the concept note, and deducing your background was from economics, and then you switched to law. And sir, this is a very genuine thing that we are confronted with, the students of Pakistan law. So the first 2 years they teach us very general courses. When I read about economics, when I studied that course, I developed an interest in that, and when I studied political science, so the first 2 years were very, frankly speaking, we were drifting like a plastic bag. But anyways, so when I look at my CV now, I have done a lot of things. I have won local Pakistan level these writing competitions, story writing competitions, creative writing, not any academic writing. So are these any worth, because we spent 2 years doing a lot of these things, but when I look at my CV now, because it's a matter of weeks, I switched my interest to law, and I'm getting serious about it. So my question is, do these extracurricular, sometimes far extracurricular activities of ours, do they help us, or these certificates are outright useless?
Yes, so let me clarify. I think I told Maham the story. So my LUM story is interesting because I decided to become a lawyer when I was pursuing my A levels. All along, I just liked economics. I wanted to do my MBA. But then when I decided to do it, it was when one of my friends, he told me there's something called a corporate lawyer. I'd never heard about it because my father was a constitutional criminal lawyer. And I just fell in love with the concept. I thought it was the perfect interface between economics, business, and the law. So the LUMS degree wasn't really sort of a divergent path for me. I was pursuing law alongside, and it was actually a deal with my parents that I still want to pursue law. They said, no, go to LUMS, prove this to us that you can get into LUMS. I did that. I'm like, I still want to pursue law. So it wasn't like, it was part of the plan. And economics, I think speaking of diversity, I'm a big believer in diversity. I don't want to bore you with the book, but there's this book called Range. It's by David Epstein, and basically what that person argues is, he gives the example of Roger Federer and Tiger Woods, and he said that Roger Federer started playing tennis when he was 13 years old. Tiger Woods started playing golf when he was 2 years old. I don't want to repeat Tiger Woods' story. He was a champion, but look what became of that champion. But his argument was that all the diversity of sports that Federer played, he played football, he went swimming, I don't think he played cricket, but he played a bunch of sports. He didn't touch a tennis racket until the age of 13, helped him become a champion. Same applies to professionals as well. And I'm a big believer in industry knowledge. I think I was chatting with Shazia the other day. I'm like, if somebody says I'm a corporate lawyer, if the question to him, so what industries are your clients in? So is there a particular industry you focus on? And most people won't have an answer. Oh yeah, we advise clients across industries. So industry knowledge is key. Being a corporate lawyer in and of itself is not a big deal. But let's say, are you an oil and gas expert? Are you a pharmaceutical expert, tech expert, telecom, right? So you have to pick at least perhaps 2-3 industries for starters and gain knowledge of the industry. You need to know the legal landscape, not just the legal aspects of it, the business aspect, the financial aspects, why people do what they do in that industry, right? So you don't have to have the lawyer hat on all the time if you want to become a good lawyer. So to your point, let me reassure you, whatever you've learned will not go to waste. It'll be beneficial. But at some point you need to, start focusing as well, that, this is what you want to do for a living. But I mean, acquiring knowledge in the process, it can't hurt you.
And I'm just going to second that. Even if you want to go into like international law and any aspect of it, you would need to know a background in something else to excel in that particular field. For instance, if you want to do public international law, having a background in history is going to help you tremendously well, even when you go to the grad school level, because you'll see how international law is based on so much history of relationships of state. And the same goes for arbitration as well, investment arbitration or commercial arbitration. I know people personally who are working at law firms who have a very strong background in accounting. So in the commercial arbitration, they're just focused on the damages aspect of that, and they've specialized in that. So some kind of extra knowledge is definitely going to help boost your CV and just yourself as a person to show you a more well-rounded lawyer.
Ma'am, I did a course. I did 2 courses on Coursera, and but those weren't of law. They were global history courses from University of Virginia. So when I was applying here to the summer school, I wasn't sure if I should add this to my CV, if this would help me, or if this is the examiner will think his CV does not have a focal point. He himself does not know where he wants to go, and so this is the question we face from this part of the POV, from their POV. I don't know what the insights are.
So I can give you my example. I did my undergrad from LUMS, the BA LLB program, with a double minor in history and psychology. So because in case I wanted to go into criminal law, I took psychology, and if I wanted to go into international law, I took history. Also, when it comes to your CV, right now, particularly with international law, I would say even if in a sentence list everything you've done, because you don't know what exactly a particular organization or a particular department or group is looking for, and the thought process of the person reading your CV. Maybe they want someone with a diverse background. If they don't want someone with a diverse background, they'll just look it off as something extra you've done. So omitting substantive stuff from your CV that you've done is something I never recommend people. I would always recommend to shorten it, or where you place it in the CV also matters with regards to where you're applying. For instance, if you're applying to a think tank associated with international law, you would want to put that you've done courses in history with your degree. But if you're applying to a corporate law firm, you should put it, but like at the end of the CV. So writing the CV, as Sir Ali Zahid Rahim also said, matters a lot, and you need to know how and to what organization your CV is going to, and to cater it to that.
want to add two things for the benefit of all the students, and I think there is a lot of anxiety at your age. You really don't know where you will be 20 years from now. जो कर रही हैं ये सारा टाइम ज़ाया हो जाएगा. It happens, yes, but at their age it's a lot more. उसमें जो है, to put that anxiety to rest. From my background, what I learned was metric. I did it in science, passed with good grades. Then I did pre-engineering. I had a position in the board. Then I did my BA, which was stats and economics. Now all these subjects, where am I going with all these subjects, right? But in my profession, once I came to law, I can assure you not even one subject I can say was in vain. I mean, every subject that I studied in life has helped me out. Sometimes you're working as the expert on software, sometimes you're having to look at the quantum issues. The kind of cases you will get, you don't know what kind of case that is going to be, and all the skill sets you acquire do help you out in whatever case you will be doing, because lawyer ka role hi is qisam ka hai. People are going to come to you for various kind of disputes. You're not an expert in the steel industry, but people would want you to know as much as you can about manufacture kaise hota hai, steel jata kaise hai, what it is. One of the cases that we were doing, after the steel has been put into the bridge, someone contested कि उसका जो है quality ठीक नहीं थी. Now you're stuck with the bridge बन चुका है, अब उसकी quality आपने साबित कैसे करनी है कि ठीक थी या नहीं थी. So you come up with all these fascinating issues, and every skill set, everything you studied is going to help you in one way or the other. So forget about that anxiety. If this is going to be of use or not, everything can be used. दूसरी जो आपकी एंजाइटी इस एज पे अगेन होती है कि फिर if you are scattered, you do not know कि where you are going, तो of course someone reading the CV is going to see that as well. So it is okay to explore. आपको जब तक वो चीज़ नहीं मिल जाती that you think you will do, even if you were not paid for it, you keep trying and you keep exploring. But once you find that thing, जो आपको लगता है कि this is something I can do for the rest of my life, उसके बाद your trajectory should be clear. क्योंकि when I came to apply for the Fulbright scholarship, so it was a big investment on their part. मेरे SJD के लिए they had to invest 5 years of education. And I think the thing that helped most in my application was there was this thread which was showing that I had been consistent in my path, regardless of the fact that I had studied all these subjects. But once I came to law, there was consistency. All the courses that I had studied, all the assignments I had taken, everything was leading in one direction. So jab tak you don't find that one thing that you think you will do, even if you had to do it for free, क्योंकि दिन में as a lawyer you are going to be spending about 17 to 18 hours working. If you are stuck with something that you do not enjoy, life is going to be a punishment. So जब तक आपको वो चीज़ नहीं मिल जाती, wander as much as you like, explore as much as you like. Everything you do, you will be able to utilize.
If I may quickly add, so when I was pursuing my LLM, I wanted to take a course in mergers and acquisitions, M&A, which is huge in the US. Of course, I am biased, but I think it cannot be taught better at any other law school. And I did not qualify for the course because they said you have to take corporate finance. And I said, I don't have many choices, just 2 semesters. And they're like, what's your background? I said, I have background in economics. Like, oh, you know what, we'll waive that requirement. You don't have to take corporate finance. And I was able to take that course. So all those 3 years of economics helped me. And to your point about having these different experiences, I think it's how you craft your story, right? They say everybody has a story, right? It's how you tell that story. You have to adapt it, customize it based on who you're sending it to. As Maham pointed out, depends on where you're applying, right? So we do this all the time as well. Let's say you're pitching for work, right? So you would highlight the relevant work, which probably did 5-10 years ago, right? It's how you craft it and pitch it that makes all the difference.
I have a question from Sir Jamal. You said that you are aiming to start degree programs. So do you have any current courses, like summer courses, that you offer for regarding public international law? And what are the courses that you would recommend the students currently who are enrolled in the universities for LLB programs to take regarding public international law?
थैंक यू जी. यस जी, हमारा जो फ्लैगशिप कोर्स होता है RSIL में, वी डू एन एनुअल कोर्स, इट्स कॉल्ड द इंटरनेशनल लॉ सर्टिफिकेशन कोर्स. सो दैट इज़ पहले एक हफ्ते का होता था, नाउ इट्स एक्सपेंडेड टू वीक्स एज वेल. वो एक फाउंडेशनल कोर्स होता है वेयर वी टेल यू कि उसकी रेलेवेंस क्या है, व्हाट इज़ द रेलेवेंस ऑफ इंटरनेशनल लॉ टू पाकिस्तान, व्हाट आर द करियर पाथ्स दैट यू कैन टेक, हाउ डज इंटरनेशनल लॉ प्रैक्टिकली किस तरह पब्लिक इंटरनेशनल लॉ की क्या पाकिस्तान का एक्सपीरियंस रह चुका है. सो दैट इज़ समथिंग विच हैपन्स इन August every year. I would encourage you to apply for that as well. उसके अलावा we are currently working on some certification courses with LUMS. So LUMS के साथ हम develop कर रहे हैं on different issues, anti money laundering and terrorism financing पे हम कर रहे हैं. Business and human rights is a huge new area because human rights globally एक movement यही चल रही है कि businesses are most responsible or can be a very effective stakeholder in the promotion of human rights, whether it is labor issues or climate related issues or whatever. तो उस पे काफ़ी काम है. There's a lot of work coming in on the development side in 2024 on the BHR space. So उनके साथ है. फिर हमारा ज़ियाउद्दीन यूनिवर्सिटी कराची में we have some programs on global governance के साथ हैं, जिसमें हम पढ़ा रहे हैं कि international institutions, how do they work, how do these multilateral organizations work, and how, like for example the IMF, how does the IMF work, and what are career paths in the IMF. Usme we are also connected with the US Embassy, which is who's giving us technical support, as well as the American Bar Association in Washington. उसके अलावा हम कायद आज़म यूनिवर्सिटी के साथ we are now exploring, we just signed an MOU, and वो ज़्यादातर international relations का जो legal aspect है, because international relations, like I said, there are very few international relations jobs in Pakistan, but if you can add वो जो बात पहले हो रही थी कि economics is a fantastic first base to have with law, economics and law, but IR coupled with law can then suddenly become a different experience as well. So इस तरह की चीज़ें हैं, but हम खुद भी we are exploring some partnerships with the external program colleges. TILS हो गया, TMUC है, CLLB है, उनके साथ हम छोटे छोटे programs कर रहे हैं. But you are free to also, we are also offering fellowships. So we have a couple of centers working on international humanitarian law. One is working on climate finance and climate change. कुछ हम कर रहे हैं on regional integration. पाकिस्तान कब से कह रहा है कि हम, ever since I can remember, we've been talking about our geostrategic location हमारी बड़ी ज़रूरत है, but उस geostrategic location का किया आपने क्या है, right? So integration with your western neighbors requires a thorough understanding of the plethora of international treaties and conventions relating to trade and transit and customs, and उसकी technical integration किस तरह हो सकती है. We are working on that as well, और वो NDU में भी हमारा कुछ उसके ऊपर on a policy side चल रहा है. So there's a lot of space. इस तरह की areas में हम fellowships offer कर रहे हैं, so where you can work with our existing team members for a 3 to 6 month fellowship, where you will publish a series of papers and also work on different policy recommendations, because law का सिर्फ जो policy side है, there is a lot of space in that, because if you want to know कि किस तरह से मैम ने भी बोला कि 1940 Arbitration Act is what we're stuck with. Now if you're going to do policy advocacy to change that act, unfortunately हमारे stakeholders के पास information ही नहीं होती. There is not, मतलब for example बाहर मुल्क में अगर आप research करें कि इंग्लैंड में रिमांड का सिस्टम या बेल का सिस्टम में क्या प्रॉब्लम्स हैं, यू कैन गूगल इट एंड यू विल फाइंड 60 odd publications which will tell you the law, the background, the state of challenges, what has happened in the past, current proposals क्या हैं, अभी state of play क्या है. Pakistan में it's all based on people's experiences, working in different setups. There are no reports, there are no publicly available documents where this whole thing has been mapped out, the issue has been identified. तो यहाँ बहुत space है. There's a lot of space where you can become a policy expert by identifying कि issues क्या हैं. I for example have a lot, even though I do international law, but मेरा काफ़ी day to day work में I work on criminal justice matters relating to extradition, relating to transfers of offenders treaties या mutual legal assistance. उस पे whether it's the FIA or the Ministry of Interior or NAB or different provincial authorities, they require support in developing guidelines, manuals, books, policy briefs, and there's a lot of work that you can do in that. And increasingly the development side of something that we've not discussed today, development side mein you are seeing a new space open up where people are earning very good money and also contributing at a policy level, and that is something which it's rivaling or even outshining law firm partner salaries in that space as well. So that is something that you can also definitely explore, and that's there's a lot of scope for these areas. Thank you.
We have time for one last question.
So, media presence at your age, it's I wouldn't say it is significantly important. Most of the organizations that I know of, when they ask you for your social profile, they are only checking your views, whether or not you are a person they want to have on board. ठीक है, बास जो लोग हैं, they have very strong views, and there are organizations who do not want to entertain very strong views. So social media presence, I think that is more of a safety check rather than trying to see whether or not you have a presence at this age. But at the same time, the presence that you can create, I would say, as Rana Sajjad Saab said, if you were writing blogs, that would be the right way to go. If you want to create a presence, write blogs, right? Kluwer offers you the opportunity of writing blogs, and it's a very good platform for young people. Write blogs for these organizations. That for the media presence, your first question. Your second question was civil or criminal. Yes. In Pakistan, the problem, I think I have faced this as well. If you specialize in an area which is extremely niche, you do have problems, right? What is commonly accepted, it's easier to get into those fields. So if you choose something which is not that commonly known in Pakistan, तो आपके एक तो avenues बड़े थोड़े हो जाती हैं, the places where you can work, right? For instance, satellite law, how many places in Pakistan you can work, right? So specialization, I feel, is something that you should start considering after you have worked for a while. So your basis should be general, right? Many of the children who are doing external courses, when they start practicing in Pakistan, they have difficulty because they know nothing about the Pakistani law. So when you're considering which courses to opt for, I think one of the important things that you need to think to yourself, and I often say this to students, you need to think about two things. One, where do you see yourself working? Are you going to be working in Pakistan, or are you planning to be working in US or UK? The second thing I often tell them is that you need to answer this question, what do you want from life, right? Some people, they would be quite happy being, let's say, a partner at a big city law firm in New York. That is enough. That is the climax of their achievements and their life. If you're thinking about doing something for the country, for instance, I mean, what is going to make you fulfilled at the end of your life? You need to be clear about that. इस वक्त आप ये तो decide नहीं कर सकते what you will do in life, but at least you should know what would be a fulfilling life. If you were on your deathbed, what would make you feel कि यार I had a fulfilled life? Okay? Once you know these answers, then it becomes easier to make those selections. Right? Definitely going into a niche area is going to make it very difficult to secure a job in Pakistan, find your way into those niche areas. When, as I said, when I became the first woman from Pakistan to become a SJD, it sounds very fancy, but two things you will find is, one, you will not find mentors. If you are a first at something, that means there is no one up there, right? You're on your own, right? Second thing that you will find in niche fields is, if there is anyone else or people who are able to support you in those areas, I might be wrong and I'm not generalizing, but many of the people you will find insecure. So many of the doors you will find closed, right? So this is particularly for the niche areas, right? So if you decide to go in a niche area, do make up your mind that it is going to be a hard struggle. It is going to be 10 times harder work than the general areas. And you need to be sure it is something you want to pursue in Pakistan or you want to pursue it abroad. If you were pursuing a niche area abroad, it might not be as difficult. But in Pakistan, definitely, it's going to be a difficult journey.
Anything to add? I just like to add one thing as well. I completely agree with Dr. Nurul Paracha. It is, if you work in a niche field in Pakistan, especially जो आपने mention किए AI and these kind of things, ये तो अभी बिल्कुल ही there are new frontiers globally as well. So it's too early to focus. Like the other speakers have also said, कि आप specialization in such an area is not advisable. You have to build your basics, और basics के अंदर जो है particularly your writing skills, your research skills, and your drafting skills. That is, whether you are in commercial or civil or criminal or international law or as an academic, these are fundamental skills to focus on. And there's a lot that you can how you can constantly grow in that as well. As far as media presence जब आप बात कर रहे थे, उसके अंदर I'm not great at it, but people in my organization, they always tell me कि आपको भी होना चाहिए, but I'm not so tech savvy. But I do think that contributing, there are so many new mediums now available. For example, आपकी podcasting का जो concept है, you can actually do, you should listen to as many podcasts as you can, but you can also start hosting eventually. Once you get a sense in some issue, you can connect with professors or academics all over the world and get a sense and build that policy space for yourself as well. But niche field का सिर्फ ये फायदा होता है कि once you do get into it 5, 6, 7 years down into your career, पाकिस्तान में उसका फायदा ये है because the bar is so low, because capacity इतनी कम है at every level, at the highest level. If you become reasonably good at what you do, your input can go right up the chain. So you can आपको head of state level तक आपकी input जा सकती है because लोग ही कम हैं. But that comes with its own responsibility, that comes with its own challenges. But regulation of these critical areas, जिस तरह आप कह रहे हैं, there's a lot of confusion right now कि ये regulate किस तरह किया जाएगा. Cryptocurrency का अभी तक हमें पता नहीं है कि हमने उसको ban करना है या उसको हमने use करना है, किस तरह करना है. So there are entities which are constantly looking for people who have developed capacity, and my colleagues, मेरे age group वाले हैं, 2-3 लोगों ने जो उसमें थोड़ा सा venture किया है, they have, they are making quite good money and they've made quite a good network for themselves because it's a global network. So there are, like I said, पाकिस्तान में challenges बहुत ज़्यादा हैं, but उसी तरह opportunities भी हैं because the capacity is so low. If you do little bit of good work, but उसके लिए आपकी ethics बहुत ज़रूरी है. You have to work on your ethics as a lawyer or as a professional when you join. That is what sets you apart, and that's why the foreign firms are so far ahead because they specialize in these things. या जो हमने बाहर से पढ़ा हुआ है वो यही है कि you realize the professionalism level that they bring to the table. That is something different. That is something, if you work on in Pakistan, if you are a proper professional with a solid work ethic and knowledge, and if you're knowledgeable and hardworking, you can, your career can skyrocket quite quickly.
If I may. So there are two quotes I really like. They say in America, good things come to those who wait. and the other one is opportunity favors the prepared. I think Nudrat or Ali referred to this as well. So you still have to be a good lawyer. I think spend perhaps 5 years, working on your craft, and then you can transition as well. I think my colleagues would agree with me, but so when I went to law school in the US, there was no such thing in international commercial arbitration, at least as a course at law schools. This is like 2001, 2002. And all the international arbitration practitioners, I'm talking about the council, they transitioned very seamlessly, smoothly into international arbitration because they were great litigators. They had the litigation skills. So it was, again, as Undar pointed out, it's not the entire skill set, but it was an easier. So if you're just waiting for the right opportunity, for the right practice area, busy, doing nothing, good opportunities won't come to you. So you still have to be a good lawyer. And then there's something called, I like the term, idiosyncrasy credit, which essentially means, silly is not the word, but you can try out new things if you have a certain credibility, right? People recognize you as somebody who's credible, who's done some good work. Then you can try out different things, and that's where the cutting edge areas come in, right? So if you're a good lawyer who's established himself, herself, and then you, let's say, start commenting, writing on, blockchain, AI, cybersecurity, all the cutting edge areas, then your opinions will be given some weight. But to get there, you still need to be very good at the fundamentals of practicing law.
That brings us to the close of this session. I would now like to request President IPRI, Ambassador Dr. Reza Mohammed, to please come and say the closing remarks.
बहुत शुक्रिया। अस्सलाम वालेकुम। नींद किस किस को आई हुई है? We all are feeling sleepy. दो हैं, मुझे भी काउंट कर लें बीच में। अच्छा, I'll not take too long. I'll begin with my gratitude to Rana Sahib, Dr. Nudrat, Ali Sahib, Jamal Aziz, and Maham. Dr. Sadia is not here. We are missing her. उनको भी बहुत बहुत ग्रेटिट्यूड, उनको सोवेनियर भी भिजवा देने। एंड आई थिंक इट्स बीन वो सीनियर लॉयर्स जो आगे बैठे हुए हैं, अब्बासी साहिबा, थैंक यू सो मच फॉर बीइंग हियर थ्रू एंड थ्रू। आई एम नॉट अ लॉयर, but I know very good lawyers, and today the number has increased, the lawyers whom I know. It's been a very useful session, I think, very useful 2 days, very knowledgeable, and I think today's session, this panel discussion should help you to decide what course you are going to choose for you in the life. But there's one thing, there's no shortcut. आपने सबसे सुना होगा, शॉर्टकट कोई नहीं है, आपने तैयारी करनी है, सीवी बनाना, कवर लेटर बनाना, मुझे खुद पता नहीं था क्या चीज़ होती है, थोड़े दिन पहले मुझे पता चला है। इट्स अ वेरी वेरी डिफिकल्ट थिंग टू डू। और फिर जैसे टिप्स दे रहे थे ना आपको जी कि सीवी जिधर भेजनी है उस लिहाज से दोबारा से बनानी है, तो आई थिंक दिस गिव्स मी एन आइडिया कि ये तो सबसे ज़्यादा इम्पोर्टेंट चीज़ है कि सीवी बनाना, कवर लेटर बनाना, द कम्युनिकेशन स्किल्स, हाउ टू एक्चुअली प्रेजेंट योरसेल्फ इन इंटरव्यू पैनल, दीज आर द थिंग्स जिसमें हमें बहुत ज़्यादा ग्रूमिंग करनी चाहिए इन बच्चों की। आई डोंट नो वेदर इट इज़ डन इन आवर यूनिवर्सिटीज़ और नो। आई नो एट लीस्ट अबाउट बीपीपी इन यूके, इन इंग्लैंड, कि वो ये भी करते थे, जो मुझे पता चला कि ड्रेस क्या पहनना है, टाई नॉट कैसे करनी है, अपने जो क्लाइंट है उसको मिलना कैसे है, फी कैसे निगोशिएट करनी है, लिखाई पढ़ाई तो अपनी जगह पे है ना, ड्राफ्टिंग करनी, ये करना, वो सारी चीज़ें सिखाते हैं, पढ़ाते हैं। By end of the day when they come out, the students come out, they are very well aware. I don't know हमारी यूनिवर्सिटीज़ में ये होता है या नहीं होता, तो कम से कम हम लोग मिलके, ये सारे जो इतने अच्छे अच्छे लोग हैं मिलके, तो इन बच्चों के लिए कोई ऐसी स्किल्स डेवलपमेंट के लिए कुछ कर सकते हैं। अच्छा, एक और इंटरेस्टिंग चीज़ मैं अभी माहम से डिस्कस कर रहा था, आई सॉ दिस नेटफ्लिक्स की एक सीरीज थी, गुड वाइफ। आई नो आप लोगों के पास तो टाइम नहीं होता लॉयर्स के पास देखने का, तो मेरे पास टाइम था। अच्छा, आपने देखी? तो आई सॉ ऑल दी एपिसोड्स, हर एपिसोड में डिफरेंट केस होता था। इट वाज सो इंटरेस्टिंग टू वॉच दैट। और एक चीज मैंने देखी जी विच इज वेरी डिफरेंट फ्रॉम आवर लॉ फर्म्स, दे हैव एन इन्वेस्टिगेटर ऑल्सो, सो वी डोंट हैव दैट वन। So they sent the investigator. She was a very great lady.
That's not legal, by the way.
नहीं मैं लीगल को तो हमारे मुल्क में और क्या अभी जैसे बैठी हैं बासी मिस बासी ने केस किया नूर मुकदम का अल्हम्दुलिल्लाह जीत गई क्योंकि इन्होंने तैयारी बहुत की थी इन्वेस्टिगेशन में बाकी जो प्रोसिक्यूशन के लिए तैयारी होती है वो क्या होता है फोरेंसिक की वो फ्लांटिंग सारी चीज़ें ठीक थी वरना आई नो ऑफ अ केस किसकी बात करता हूँ मैं एनीवे आई विल नॉट रेफर टू पर्सनल है डॉक्टर ने पोस्टमार्टम की रिपोर्ट चेंज कर दी रोजे थे तो उसने सिर्फ इतना लिखा कि स्टमक में जो फूड था वो फ्रेश था तो टाइम ऑफ मर्डर जो है वो डार्कनेस में चला गया कातिल बरी हो गया तो ये इन्वेस्टिगेटिव जर्नलिज्म और ये जो फोरेंसिक्स हैं ये बड़े इंपॉर्टेंट है आप लोगों का काम बड़ा मुश्किल होता है करना एक और इंटरेस्टिंग चीज मेरे जहन में आई कम्युनिकेशन स्किल्स When we went into the army, अभी तो मेरे रिटायर हुए भी काफ़ी साल हो गए इट वॉज 1978 when I joined army तो उस वक्त आर्मी में कोर्स एनसीओ बनने के लिए प्रमोशन के लिए सिपाहियों को करवाते थे उसे कहते थे उर्दू रोमन उर्दू तो मुझे पहले समझ नहीं आई बाद में याद आया बाद में देखा जब तो पता चला कि उर्दू को इंग्लिश वर्ड्स में लिखना क्योंकि अंग्रेज जो थे वो उर्दू बोल सकते थे लिख नहीं सकते थे तो उसके लिए ये इजाद की गई थी रोमन उर्दू और आजकल आप सारे बच्चे रोमन उर्दू पे लगे हुए जितने मैसेजेस उर्दू में जा रहे हैं भाई अंग्रेजी में लिखो ताकि अंग्रेजी तो इम्प्रूव हो तुम लोगों की और सेल्फ इम्प्रूवमेंट के लिए आपने खुद मेहनत करनी है आई नो पीपल जो बहुत ही मीडियोकर बैकग्राउंड से आए वो हमारे एक दोस्त था वो कहता था कि जब मैंने पढ़ा तो हमारे स्कूल में जो पढ़ाते थे GIRL गर्ल मैंने छोरी मैंने लड़की तो जब ऐसे बैकग्राउंड से लोग आते हैं फिर मेहनत करते हैं तो जब आगे जाने जाते हैं तो सेल्फ इम्प्रूवमेंट जो सारे लोग ये बैठे कह रहे थे अपने ऊपर जरूर मेहनत कीजिए वो किसी पे आप गिला नहीं कर सकते मेंटोरशिप की भी बात हुई है आप खुद ही अपने मेंटोर हैं खुद ही अपने गाइड हैं और खुद ही अपने लिए आपने मेहनत करनी है लास्ट पॉइंट स्काई इज द लिमिट लास्ट हंसी के लिए आपको बताता हूँ ये जो टाइम की बात मैं अनुद्रत कर रही थी 17 घंटे वाली सूफी साहब आए हमारे घर डिनर पे तो माय सन वाज अ लॉयर ही स्टडीड उसमें BPP जिसकी मैं एग्जांपल दे रहा था तो उसकी वाइफ ने पूछा अंकल ये अब मेरे बेटे का नाम उमर था कि बड़ा लेट आता है ये रात को ना तो क्योंकि वो जब आप इंटरनेशनल काम कर रहे होते हैं तो रात लेट आते हैं तो कब तक ठीक हो जाएगा तो इन जवाब दिया 2-1 साल तक बेटे ठीक हो जाएगा तो उसका अच्छा जल्दी आया करेगा नहीं कहते हैं तुम आदी हो जाओगी बस आई थैंक यू ऑल इट्स अ चैलेंजिंग फील्ड बट वंडरफुल फील्ड एंड पेइंग ऑल्सो जैसे मैम नुदरत कह रही थी $3,000 पर डे ओनली ये भी हो सकते हैं विश यू ऑल द बेस्ट थैंक यू सो मच
Because he has to leave, he's running late for another meeting. So please.
My son is done from tomorrow also. Thank you.
Management